was that board properly constituted?
Chair, the board was not properly constituted at the time that Judge Makhubele was appointed as the chairperson of the board. In fact, if I may explain, the board of Judge Makhubele was an interim board. It was labeled that, and it was not properly constituted because it did not have all the required, functionaries in terms of legislation for a properly constituted board. And I guess also further, the fact that, there's nothing such as an interim board that is catered for in the Legal Succession Act, which is a statute that governs and dictates how the composition of the PRASA board is supposed to be.
Okay, Ms. Ngoye, I am going to ask you to go a little bit slowly. Okay. We are taking notes. It becomes very important. And just for, there is no running record at this stage, so we are relying on the notes that we take down. Thank you.
I'll do that.
Okay. You've indicated that there is legislation that regulates the composition of a board. What legislation are you referring to, and do you know which section is that?
Yes, Chair. It's the Legal Succession Act. It's, I think it's section 24 of the Legal Succession Act that speaks to the composition of the Board of PRASA.
How many people are, which functionaries were supposed to form parts of that board?
Well, the Act provides that obviously the chairperson will be appointed by the minister. It provides that there has to be a representative from the Department of Transport. It has to be a representative from the Department of Finance. There has to be a representative from business, commercial. And it also, under finance, it gives a bullet point that talks to, somebody with a financial background as well. So, and then it talks to the number 11, that the board must be comprised of 11 members.
Now, in what way, if I may, was the interim board not fully correct, as they would say, when Judge Makhubele joined the board?
Chair, one of the important functionaries that was not part of the board was a representative from the Department of Treasury, right? So it just has to take one of those mandatory representatives not to be there for that to have an impact on the creation of the board.
So the board wasn't curate, as they say, because there was no representative of the Treasury on the board
as an example. Yes.
Anything else as far as you can?
Well, I guess the number of the board, Chair, was less than the 11 that is stipulated in legislation. So, but I guess for me, the important representative, is what is mandatory in terms of legislation.
Thank you.
Thank you, Chair. Ms. Ngoye, if a board is not properly composed of, what becomes of the decisions that the board then makes?
The decisions are not binding, Chair. You know, it creates a problem. The decisions are not binding. They can be challenged, you know, by anybody who's not happy with those decisions. But effectively, they're not binding.
I want to refer you to a document called a delegated authority document. You will find that in volume 8, volume 8, and it's on page 51. The number is on top. Volume 8, page 51. And I'm also going to refer you to volume 6, starting on page 975.
Is it 974?
It will start at 974. That is the outside cover, but really I want you to go on to page 975.
I've got the documents, Chair.
Thank you, Ms. Ngoye. It's volume 8, page 51, and volume 6, page 975. Got it. Okay. Right, let's start off with the volume 8 document on page 51. And it is on the outside cover, it's Passenger Rail Agency of South Africa, Powers, Authority of the Board, and Delegation of Authority. You see that?
That's correct, Chair.
And you've mentioned even with regards to the volume 6 document, it is noted as on the outside cover on page 974, it's written section 3, Delegation of Authority.
Yes, Chair.
Okay. This document in volume 8, are you aware of it?
I am aware of this document, Chair.
And the document in volume 6, are you aware of it?
I'm also aware of the document in volume 6, Chair.
Okay. Let's deal with the one in volume 8. What does this document deal with? This delegation of authority document, what does it deal with?
This document, Chair, is a board document. And once again, I think I'm going to go back to the Legal Succession Act, which does mention that, you know, because PRASA has a board of control, the powers of running the institution are delegated to the board. So when the board comes in, they put this document together because it then explains how it is that they would like the organization to function. So this is a board document which would specify the responsibilities, amongst others, the responsibilities of the board, the responsibilities of the group CEO, the responsibilities of various executives, group executives, and it would also indicate what the limits are, right, that they would want to regulate within the organization. For instance, in the volume 8 delegations of authority, the delegated authority of the group CEO at the time was 50 million rands. I've looked at volume 6, the delegated authority of the group CEO was 100 million rands. So the board comes in and obviously they look at this particular documentation and they would then decide what it is that they feel comfortable with. And they would set those limits and indicate who's responsible for that. But I must also say, Chairperson, that the board, my experience, perhaps let me put it that way, is that the board does not necessarily do this when they look at the delegations of authority alone. They would involve the group executive team in so doing, and discussions would be held, with it. But ultimately, they have the final say of what it is that they want contained in this document.
When you say they involve the group executive, who would that be? Who would that have been at this time?
Well, it's the group exco, the group executive team, that would be involved, because a lot of the responsibilities, obviously, that they dictate to in here would affect those particular group executives. So it became natural that right at the onset, when the board considers this, it doesn't do it alone. We understood it to make sense that way, because then everybody, at least in the executive position, would understand what their roles are and would have had an input as to what they believe, should happen as far as their roles. But as I said, ultimately, the board didn't have to agree with the executives. They would then have the final say.
Did Judge Makhubele's board, the interim board, have a delegated authority?
Well, Judge Makhubele's board, when they arrived, there was a delegated authority document, delegations of authority document, that existed. So the organization will always have a delegation of authority document. And the one that was operational at the time, for lack of a better word, would have been the previous board's delegations of authority. So what Judge Makhubele's board would do is that obviously they would look at the previous one and then decide to put their own together. So at the time, my appreciation is that the previous board's delegations of authority would have been the one that was applicable.
Do I understand from what you say that the interim board that convened under the chair of Judge Makhubele wasn't given a specific authority, but they simply carried on with the authority that had been given?
No, Chair.
Yes.
How it works is that they have the authority in terms of legislation, right? However, they need to put a document together for their purposes as this particular board. So at the time, they had not had an opportunity as Judge Makhubele's board to finalize or sit and look at the delegated authority that was existent. So the organization would function on a delegations of authority document that would have been approved by the previous board until such time that they would have finalized theirs and then allowed that to kick in.
During the period when Judge Makhubele's board was sitting, is it possible to indicate whether there was a delegated authority that was circulated with the group executives, which indicated the responsibilities and functionaries and what was expected of all the units?
No, Chair.
Sorry, if I may, Judge Moshidi here. Was Judge Makhubele not appointed by the minister as interim chair?
I guess he was.
Sorry?
Chair. He was chair. My understanding is that he was. Because
She was.
I'm sorry, so sorry.
Huh?
She was, yes.
Did you have sight of the letter of appointment from the minister to her?
No, Chair. I mean, I guess we assume that that is how it is done, and we don't get to see those documentations.
Can it not be inferred from that letter of appointment that she had authority to
Chair,
do,
she
to
did
do
have
what she did there when she arrived in October 2017?
I'm not disputing that Judge Makhubele had authority. What I'm trying to explain, Chair, is that the legislation gives the board authority, right? So when she is appointed, I don't know whether her letter of appointment would tell her what her authority is. I don't know that. I've never had sight of that. But the legislation would be at least a document that exists that the judge would have reference to in relation to her authority. So I'm not suggesting that she didn't have authority after her appointment.
She may have had authority when she arrived there.
She may have. She had authority.
Yeah.
Yes, I'm not disputing that.
When whilst I'm there, I'm looking at paragraph 9 of that document before you. It deals with the chairperson of the board. It's on page 61. Paragraph 9.
Yes, Chair.
Is that all that is said about the authority of the chairperson there?
Yes, it's
As far as you know.
Paragraph 9 deals with the specific.
Sorry?
Yes, Chair. It deals with the specific authority of the chairperson
Yeah.
in the years. The other provisions talk to board matters and so on.
What do you understand under paragraph 9 to be the powers of the chairperson?
The chairperson could sign, is authorized, as it says, to sign the MOU.
I mean, what's your interpretation? What is your understanding of the authority set out there in paragraph 9?
Chair, it's very clear to me what the authority of the chairperson is. They can sign the memorandum of association, of memorandum of understanding. It says there. It says also in the section 8 document, it talks to donations also may be made by the chairpersons of the board in terms of what is approved by the board as part of the budget of the year. So it is specific, and it's very clear. I mean, I read it and understand it to say exactly what it is saying. So there is no need for me, I guess, to look at it any differently or to try and interpret it any differently. I read it as it is and I understand it what it means.
Could I just go back to your own personal qualifications, including legal and or experience? Because in her documents, Judge Makhubele tells us that she struggled to be where she was. The usual issues that resonate with most of us in this room, and she ended up first being a nursing sister before she went into the legal profession. So it would be your weight against her weight, but let me first have your formal qualifications and experience, legal-wise.
Chair, I matriculated in 1987.
Yeah.
After matriculation, I went to varsity. So my first year of varsity, because my parents did not have sufficient resources to take me to varsity on a permanent basis, I went to UNISA. So I took a couple of courses with UNISA, but in the legal stream, because I'd always wanted to become a lawyer. So at the end of 1988, I managed to secure a bursary with Siemens Limited. Now, Siemens Limited was a company that employed my father. In fact, what happened is that I basically picked up a leaflet at home that my father had brought back from work. My father was a driver at Siemens. I just picked up that leaflet and I realized that on that leaflet, it catered for employees' benefits. And one of them was, the ability to assist employees' children with bursaries. So I took that opportunity and I applied at Siemens without even telling my father that I did. And I went for an interview at Siemens and I was successful. In 1989, I was then able to go full-time to university. I went to the University of the Western Cape, where I studied a BProc degree.
You studied what?
A BProc.
Oh.
Yes. I did 4 years of BProc at the University of the Western Cape. And then I applied to the University of the Witwatersrand for my LLB. Again, the bursary that I had only covered me for my undergrad degree. So when I got to WITS, I applied. At the time, it was called, I think it was TEFSA, the equivalent of the NEFSIS that is available now. I applied for that bursary. I had good marks, Chair. I was a diligent student. So I was quite confident that somehow I will get some form of funding. I did apply for TEFSA, and I managed to get, in fact, 100% funding from that perspective.
In short, did you have further qualifications after BProc?
I had an LLB. I've got an LLB, and I obviously did my articles, and and practiced with Edward Nathan and Friedland at the time. And then I left practice in 98, and I've been in corporate from 98. Various corporates. I've worked in the banking sector and SOEs.
Thank you, but do you know what? I want to get straight into the contentious issues in this matter. And reading the documents and your affidavit and evidence elsewhere, do you agree with me that the allegations that you make against Judge Makhubele are serious in nature?
Yes, they are, Chair.
Very serious.
Very serious, yes.
Do I also observe correctly that you and Fanny and the other gentlemen at PRASA appear to be angry with her?
I'm not sure.
Am I wrong?
No.
You seem to be very angry with her.
No, Chair. I want to disagree with that. We're not angry with Judge Makhubele.
No, I'm asking this because I want to see if your evidence is not biased.
I'm not biased.
That's what I want to clear up in my mind. Your word against that of a judge.
Chair, I'm a professional in my own right. And in fact, can I say this, Chairperson? When Judge Makhubele was appointed to PRASA, we were very happy as the legal department, extremely happy, because we believed, thank goodness, we've got somebody who's going to lead the organization, who's got legal knowledge. So sometimes we found it difficult when we had to engage with some members of the board who did not have an appreciation of, legal issues. So in this particular case, we were very happy as the legal function that we have somebody of the stature of Judge Makhubele who was coming in to lead the organization. So I am not angry I was never angry with Judge Makhubele, and I had no reason to be.
I believe at some stage you left PRASA, is it?
I left PRASA. No, I never left PRASA.
You didn't resign and came back?
No, Chair.
Or left and came back for whatever reason?
No, Chair. I've always been at PRASA. I was employed at PRASA, a subsidiary, Interside Asset Investments. I started there. And then in 2014, through the board restructuring, they requested me to take care of the legal risk and compliance function. This was the group board. So I've never left. I've been there since 2011, effectively, to date.
I do not want to preempt issues, but am I correct in observing that your version on the papers and elsewhere, Zondo Commission, is the same as that of Fanny Tingiswayo and the other two gentlemen? You're all singing the same song against Judge Makhubele.
Chairperson, I worked with Fanny Tingiswayo.
Sorry?
I worked with, as I indicated, Fanny Tingiswayo reported to me. So I don't know which other two gentlemen, the chair is referring to. Perhaps, because I don't know what that reference is in respect of. But what I know is that in relation to Fanny Tingiswayo, I can categorically say yes, we understood matters in the same way, and we saw what was happening in the same manner, and we dealt with issues, consulting, obviously, each other and dealing with them in the same way. So naturally, our approach and understanding of things would be the same.
I do not want to preempt or judge things ahead of time, but if they come here, Fanny and the others, they'll give the same evidence as your evidence. It's there on the papers. They'll give the same evidence.
They'll speak, they'll say what they understand, Chair. I mean, I can't say, the papers are there, yes. When I deposed to the affidavits, they may have further explanations of certain things. And Chair, I need to be guided here. I don't know who the other two people are. Maybe can I be helped there so that I know what I'm dealing with here? I don't know who the other two are. I can only speak to Fanny Tingiswayo. He corroborated the submissions that I'd made in the affidavits that I gave and I signed. So I don't know who the other two are.
Well, I mean, I'm anxious to get to the end of this matter without curtailing you. And Judge Makhubele equally is anxious to have finality in this matter. And I'm asking these questions because if they come here and give the same evidence as you, then it may not be necessary to call them at all and curtail these proceedings.
That's not my decision, Chair. I don't know.
Well, it may not be in your hands to decide that, but I'm just suggesting that. Thank you, Chair, for now.
Yes, Mzungu.
Sorry.
No, thank you, Judge Moshidi. The delegation of authority is an important document because it relies, there's a lot that flows from this. Ms. Ngoye, just to remind that you indicated that there was no delegation of authority document from the board that Judge Makhubele chaired.
Yes, the board had not finalized their own delegations of authority document that would have been signed by Judge Makhubele as the chairperson of the board at the time.
Okay, and what delegation of authority then did you rely on with regards to the performance of the duties as you went on, since there was no document in existence?
Chair, as I explained, the previous board's delegation of authority would continue to apply until changed by the next board. So we relied on the previous board's delegation, and that's what we used.
And when you say you relied on the previous board's delegation, we've got two documents that I've given with regards to volume 6 and regards to volume 8. Which one between the two volumes was the one that you relied on?
The one on volume 8, Chairperson, would be the one that I relied on, because that is the document that I attached to the affidavits that I made.
Before we proceed any further, as I indicated, the one in volume 6, do you know which board gave that document or gave that delegation of authority?
Chair, this would have been the board of Mr. Sfiso Buthelezi. I know that, Chair, because when Chairperson Sfiso Buthelezi was at PRASA as the chairperson of the board, I was an executive at that time as well. So I was privy to the delegations of authorities, a document that that board, had signed off on.
And when was that?
As I said, I've been there since 2011. So, the delegations of authority would have existed, and I think there was a year when it was amended. But we would be advised, obviously, of the amended delegations of authority, and we'd work with that. So, yes, I am aware of that, and I'm aware that when the Popo Malefa board came, they looked at the delegations of authority. And it is important for me to say, Chair, that at the time of the Popo Malefa board, the issue of contention between the executives and the board at the time was around the amount that was given to the group executive as these delegations of authority, because it was reduced from 100 million to 50.
Now, Ms. Ngoye, this morning I was provided with a document, and Chair, I'm not sure if the chairpersons have been provided with the same. It's headed Minutes of the Meeting of the PRASA Board of Control, held on Monday, 30 October 2017. Do you have a copy of that minutes before you?
I do, Chair.
Just for the record, we have been given a copy of that.
Chair, I just want to place on record that we are not opposed to the documents being part of the bundles that we've got.
Well, if there's any objection from Judge Makhubele's side, we will hear from Advocate Maleka whether there's any objection.
Chair, we don't object at all. In fact, we would suggest that the document should be curated in the last of the bundle of the documents.
Yes, thank you. Yes, please go ahead.
Thank you, Chair. We will deal with the issue of numbering it at the end. I want to take you to, am I correct that if you look at that document, the persons that were present at that meeting, you were not one of them?
That's correct, Chair. I'm not in that meeting.
I want to take you to page, page 6 of the document. Page 6. And I'm going to take you to paragraph 7.2 on that page, where it deals with the delegation of authority.
I'm there, Chairperson.
Thank you. It reads as follows. The board noted that the current delegation of authority has not been reviewed, and the board was advised that a process was underway to appoint a consultant to review the PRASA group delegation of authority and the governance framework.
I note that, Chair.
Were you aware of that?
No, Chair, this is a board minute. You know, I'm seeing it for the first time this morning.
Is it therefore indicative that the board at that time, being the 30th of October, was busy with this issue?
Yes, well, it clearly appears that way, Chair, that they realized that it's a document of importance that needed to be considered by them.
And do you know whether a consultant was ever appointed to review the delegation of authority that was existent from the Popo Molefe board?
No, Chair.
And then if you go to 7.3.1, on the same page, it reads, the board resolved that the current delegation of authority to be circulated to the directorate. Was it circulated?
The board resolved that the current delegation of authority be circulated. I don't know, Chair. I mean, I wasn't there. It's a minute of the board.
That is okay, Ms. Ngoye. Now I want to also take you to the document in volume 8. Same document, the delegated of authority document that you relied on. And I want you to take you to page 74 of the document. Well, page 74 of that volume, which has got a table on it.
Sorry, I've lost my place. I closed the bundle. Sorry, I'm looking at the wrong one. What's the page number again?
Page 74 of the record. It's volume 8.
I'm there, Chair.
In that document is reflecting certain, it is a table and it's got certain headings to it. Chairperson, one of the things that was brought to our knowledge that because of the photocopying that has been the copying of this document, the headings of the table are no longer visible to everyone. And at the time when I did speak to one of the members from the respondents team, I indicated that in my bundle, the part A and the part B that had been given at the time when the bundle was given to me, the headings were still visible. So I was wondering if I could read them out so that everyone knows I'm not sure if it's visible there on the record.
No, it's not on mine, Chair.
May I read them out then?
Yes, please.
It was also printed for us later. I mean, the headings on top there. Is it possible?
I will try, Judge Moshidi. The problem is that the more you print, the more it becomes blur. That is why on the record it is blur. But can I then read them out so that the notes can be made? And I've got a copy with me.
Yes, proceed.
Thank you. The first column where the numbering is, that is just number. The next column is a description of powers, activities, and duties that are delegated. So it is description of powers, activities, and duties that are delegated. The next column, it's accountable. Let's first start on top where it's the responsibility delegated to. On top, responsibility delegated to. Then under that, it's 4 columns. 1, 2, 3, 4. The first column is accountable. The next column is responsible. The next column is consult. The next column is inform. The final column is conditions and limitations, limits and remarks. That's the remarks column.
I'm sorry, can I ask you to repeat the last column for us?
Conditions, limitations and remarks. Conditions, limitations and remarks.
I think for clarity's sake, just let's have all the columns again, so we
Okay.
know what we're talking about.
Okay. Column 1 is just the numbering. Column 2, the biggest column, is written description of powers, activities, and duties that are delegated. Then we get on to the next column, which explains the 4 blocks. The top is written responsibility delegated to, then it's 4 blocks underneath. The first block is accountable. The next block is responsible. The next block is consult. The next block is inform. Then the final block is conditions, limitations, and remarks. Okay. May I proceed, Chair? Yes, please. Thank you. Ms. Ngoye, if you can explain to us what was the purpose of this table?
Chairperson, the purpose of the table was to be explicit as to what responsibilities or, powers, for lack of a better word, were, delegated to which functionary. And the document right at the onset would have given a descriptor of the various acronyms that are there.
And am I correct that the descriptives as contained in that document can be found on few pages before, which will then be page 62 of this document of volume 8. The functionaries are described on page 62 on the table marked as 12 key to levels.
That's correct, Chair.
Thank you. Can we go back to to page 74? Now, I want to concentrate on the functionary legal claims. Do you see that?
I see it, Chair.
Thank you. 38A says to institute or defend legal arbitration, quasi-judicial or administrative proceedings, or to oppose any appeal against any judgment, sentence, or order of any court or other authority subject to one below. When it says accountable, under the column accountable, it says GCEO. Can you see that?
I do see it, Chair.
When we say accountable, what did that mean? When you use the word accountable, what did that mean?
Chairperson, in this particular respect, the group executive would have been accountable because he is the person that reports directly to the board. So accountable, the understanding that one has is that he would be ultimately the person that would have to account for, issues pertaining to this particular responsibility ultimately. So that's what it means in the simplest of terms.
And who was this GCEO at the time?
This was in 2017.
We were now
we're talking.
we're talking about between October 2017 and 2018.
We had an acting group CEO, Chair. His name was Lindikaya Zide.
The next column is, we said it's in regards to responsible. What does it mean, responsible? What was the meaning of that responsible?
Chair, the word responsible in relation to this particular delegated authority would be given to the person here. It says HOL. HOL would be the head of legal, which is the designation, which was referring to the group executive of legal at the time. And it would be the person who basically runs with the matters as described there, institute and defend. So that responsibility would sit with the head of legal.
And who was the head of legal at this time?
I was a group executive responsible for legal, risk and compliance, Chair, as I said.
The next column speaks to consult. What did it mean for this document?
Chairperson, consult, I guess it says that and it talks to EXCO there. As the group executive, I was a member of EXCO, so effectively the issues that would arise in relation to litigation would be reported to EXCO by myself in relation to whatever it is that we were dealing with. And also, Chair, how it worked is that in relation to the matters that would come to the legal function, there would be an executive in the various divisions that would be responsible for, those particular matters ultimately. And we worked together as and when required. And they were members of EXCO.
The last column is inform.
Yes.
Can you explain that in the context of this document? What did it mean for that document?
So the inform means BOC would be the Board of Control. It refers to that. So it requires that the board be informed of the legal matters that the organization was involved in. And that was done to EXCO, it was done on a monthly basis, Chair. We prepared a report to EXCO. And then to the board, naturally it would be on a quarterly basis or as and when the board sat, a legal report reflecting the litigation would be submitted to the board, highlighting obviously those that were strategic, because in any given time there were a lot of matters that were running at the same time at PRASA. So the board would be informed through the board meeting, and the circumstances changed, Chair, depended on the nature of the litigation we were dealing with.
Okay. I want you to go to the next page of the document, which is page 75, number 40 on that table.
I'm there, Chair.
Thank you. It says to settle any claim under the description, to settle any claim by or against PRASA or dispute with PRASA, whether or not proceedings have been instituted. And it says the person who was accountable for this was the GCEO, which you've explained was Lindikaya Zide. Am I correct?
That's correct, Chair.
And then the person who was responsible was the HOL, which is yourself, if I understood it correctly.
That's correct, Chair.
And then it goes to EXCO under the column consult. And then the last column is BOC, which is to inform. You then inform them if there was any settlements.
We did inform the board, yes, through the reporting. Yes, Chair.
I want to understand this. These powers were delegated according to this document to this unit as reflected as legal claims. Or anything to do with legal claims, this is what would be followed.
Yes, Chair. I mean, we deal with these issues in consultation, obviously, together with the various, as I've explained, the various business units. Because the legal department, Chair, if I can go further, is that we would get instructions coming into our area from the business units, and naturally we would work in conjunction with, the business units. And then ultimately it was our responsibility to prepare the legal reports to EXCO as well as to the board.
And I want to take you to page 58, still on that document, but page 58, a few pages before. And I'm going to take you to paragraph, the one marked as 6.2, but with specific reference to 6.2E.
I'm there, Chair.
Page 58 of the document. Page 58 of the document, or of the volume, page 58 of the volume. I'm taking it to with specific reference to paragraph 6.2E and F, which reads, the powers delegated are to be exercised subject to the terms and conditions set out herein. Specific reference to E, may at any time be revoked or varied by the board. If the board may confirm, vary, or revoke any decision taken by a delegate as a result of a delegation in terms hereof, subject to any rights that may have become vested as a consequence of the decision, as required in terms of the PFMA. Any such variation shall also be in writing.
Yes, Chair. I understand that.
You understand that?
Yes.
Now, meaning what needs to happen if there's been a delegation and there's a revocation, what needs to happen?
Well, naturally, Chair, if there is a delegation and it is the board had the powers to revoke the delegations, because as I've explained, this is their document. So they could take away the delegated authority. But obviously they would have to advise and inform, that particular decision accordingly, so that we know, I suppose, as executives who are running the operations, what it is that we could do and couldn't do.
And it must be in writing.
It has to be in writing, Chair.
Thank you. Now, you've indicated to this tribunal that you continued to implement this delegation of authority. Was there anything that was placed in writing before you that the delegations as contained in this document had been revoked in any way or taken away from your department?
No, Chair.
And just to finalize on that delegation of authority, this is the document that was in existence throughout the period of October 2017 until March, or at least April 2018.
That's correct, Chair.
Thank you. Ms. Ngoyi. Now, I'm sure it is common cause that we are all aware that PRASA had a contract with a company called Siaya.
It had various contracts.
Various contracts.
Chair, with the Siaya group of companies.
And at some stage, there were legal disputes that arose between CIAA and PRASA, am I correct?
Yes, Chair.
Are you able to give us, it's just a background when these legal disputes started?
Chair, I think it was around about 2015, we received summonses, as I say, from the two various companies with the name CIAA. They differed. We had a summons from CIAA Rail and summonses from CIAA DB Consulting. I think it was referred to as that. And all in all, I think there was about 5 summonses that we received at the same time. And when those summonses were received, they were brought to the legal department by the respective business units that were dealing with the projects that those summonses related to.
Yes.
Yes, Chair. And perhaps if I may explain, Chair, how the legal function operated. Can I do that?
Well, I think you can do that after we take a short break.
Okay. Thank you, Chair.
Thank you. We will stand down and adjourn for about 15 minutes. See, they're having tea on that side already. Have some.
Oh, my handbag. And my phone is going off and off. I don't know what is going on. I don't even check who's calling me.
an operational perspective in relation to the matters and the summonses that would come through, I would not necessarily get a summons and then decide I'm going to brief lawyers here, and so it would come from the bottom up, and I got involved on a monthly basis with my team, where I got to understand, obviously, the workings within the department and what matters were involved, and we're litigating with it, because at the end of the day, when I go to EXCO, I go alone. When I go to the board, I go alone. So it was important for me to have an appreciation of the matters. But the nitty-gritties and the details would obviously be handled, at a particular level. And if I needed to know more information, I could always ask for it.
Let's go back to the issue. You indicated that the departments then received the summons.
I beg your pardon, sorry, I didn't get that question.
You indicated that the departments which would be in the business units received the summons.
Yes.
What then happened?
They would naturally bring them to the legal department and ask for assistance. And Chair, because it's a summons, we would obviously assess the merits in conjunction with the business units. And if we believed that PRASA did not have really a defense or the basis to challenge the particular summons, we would then advise accordingly. And we would then take over and, speak to the other side's attorneys in trying to resolve the matters. But where we believed that there was merit and we needed to defend the interest of PRASA, we would do so. Obviously in conjunction with the business units and having received all the information that we would have required from the business unit. And lawyers would then be appointed. External lawyers from a panel would be appointed to represent the organization accordingly.
And Ms. Ngoye, with regards to the CIS summons, what happened after they were received?
They were received from the business unit. They came to the department, and based on the merits of the cases and what we were advised from the business units, and based on the information that the team had received, it was clear that we needed to defend PRASA, because what we understood and what we were advised was that PRASA was not liable, as we had been sued for. So we then continued to brief a firm of attorneys. We briefed Diana Mahashwa, and to handle the matters for us and to enter the necessary notices and deal with the matters accordingly.
Well, let's just take it step by step.
Yes, Chair.
The business unit received the summonses, and you say there were 5 summonses.
Yes, if I recall, 5.
Where would they take these summonses to?
So once they would then bring it to the legal function, and Fani Dingiswayo would receive the summonses as the head of legal, and he would distribute the summonses as he saw fit.
Now let's just deal with the summonses received from CIA.
Yes, Chair.
When did PRASA receive these summonses?
I think it was in 2015, Chair. 2015, 2016, somewhere there.
What happened with these particular summonses?
The summonses were dealt with by the legal advisors within Group Legal, together with the responsible managers within the business units. before we briefed attorneys. So that's what transpired, and then once the team was happy that there is merit to defend the summons, a firm, Diala Mahashwa, was then appointed and given instructions, and then the summonses would be obviously handed over to the law firm to assist, with the proceedings.
Is that what happened?
Yes,
to
Chair.
The 5 summonses that you referred to earlier?
That's what happened, Chair.
So, in 2017,
Yes.
when these summonses, how did the issue then arise with the interim board in 2017? Because as I understand the evidence, it would have been latest, as far as you can recall, that you had received these summonses, and they were then being taken care of by a firm of attorneys, which you have instructed to do so.
That's correct, Chair.
And your understanding was that PRASA had a defense to these summonses.
That's correct, Chair.
Then what happened?
So, Chair, in 2017, when these matters were ongoing, as part and parcel of the litigation process, the parties then agreed to then rather refer the matters to arbitration, right? It was by agreement. We deal with it on that basis. There's 5 summonses, So that was fine, but it was ongoing. And so I'll talk to 2017, what transpired. I had been called by Judge Makhubele to a meeting. It was my second time that I'd met with the judge in her office at PRASA. And on the second occasion, I think it was the 14th of November, she raised the issue of CIA with me, the summonses pertaining to CIA. At the time, Chairperson, one of the group of CIA entities, CIDB, had, put itself into liquidation. So we had a liquidation process that was undergoing. And there was a section 417 that was underway. And naturally, as PRASA, what we did, we requested the attorneys that were representing the organization at the time to have a watching brief in relation to those particular proceedings. And this was also occasioned by the fact that some employees, right, within the organization, in the business unit, were subpoenaed to come and appear before that. And when employees see anything legal, they would naturally come to us. So we then requested the law firm to sit in and observe. So when Judge Makhubele calls me into her office on this particular day, she asks me specifically about the CIA matters. And I'm like, yes, Judge, Chairperson, I'm aware of what is happening. And why are you people proceeding with defending these matters? So I was a bit startled.
Let's just get clarity on that. You were called into the office by Judge Makhubele on the 14th of November 2007.
Yes,
and
Chair.
you recall this was the second meeting that you...
Yes, because the first meeting that the chairperson had called me for, it was just before they were going to the portfolio committee. Transport, and she had asked me about the worksman's investigations, for instance, because that was a hot potato, I suppose, at the time. So I explained to her what was happening and, you know, where we were roughly with those, and nothing further, effectively. And then the second time, which is the following week, when she called me to speak to the CIR matters. And as I say, Chair, I'm aware of, you know, what is happening in light of the reports that, you know, get distributed within the team and what I understand from the team. So I knew very well that we were defending these matters, and also the fact that we had a good defense as far as these matters are concerned. So when the judge asked why it is that we are defending these matters and these matters are not being settled, you know, I was taken aback, because I know we've got a good defense as far as the organization is concerned, and we're proceeding with that. There's nothing wrong with settling matters, Chair. You know, you cut costs and so on. But at that time, I knew we had a good defense. So then the chairperson, Judge Makhubele at the time then says to me, "You are aware of the Section 417? I said, "Yes, I am aware." And she says to me, "Are you aware that concessions were made by employees of PRASA at the 417? So I was, once again, I didn't know what the chairperson was talking about. I said, "No, I'm not aware that concessions were made by the employees." You know, and I think if they were, this would be the type of information that one would have expected to know, because we had our external lawyers who were representing us at that time from a watching brief perspective. So nothing had been said to us in relation to the concessions. So it was the first time I'm hearing of that from the chairperson. She continues to say, out of collegiality, this is the word that she used with me, collegiality, I have received a report that pertains to the Section 417. So I had not seen the report. And she said, look, she obviously has got relationships with the person that she's received this report from, because they've worked together in Pretoria. I said, Chair, can you share the report with me? And she said, yes.
Sorry, just before you moved on, who raised the issue of CIA? Did you raise it, or did Judge Makhubele raise it?
She raised it with me, Chair.
And it was raised with her, on your understanding, by a friend of hers, or...
Well, what she said to me is that in relation to the 417, out of collegiality, somebody raised it.
Yeah,
and gave her the report of what had transpired at 417 at the hearing. Now, I was not privy, obviously, and I didn't know that a report had come out. So I requested Judge Makhubele to share a copy of the report with me so that I can understand what she was talking to. And she said, no, she can't share it, because once again, it is out of collegiality that she has been given this report. So I, was left dumbfounded, because now there's this new information that is coming before me. I don't know. I must go back and consult with my team to then say, what is happening here? And what the judge then requested was she wanted reports, a report in relation to the particular matters, the summonses and so on. She inquired the law firm that we were using, and I said, we've got Diala Mohashwa, who has been on brief and who has been running with the matters. So I'm happy to provide the reports from the group legal function, as well as engage with Diala Mohashwa to give the chairperson the information that she required. And I left. In that meeting, Chair, I must say that the acting group CEO, Lindika Azide, was present. So it was just the three of us. So I left, Chair, and left him with the chairperson. When I went out to go and establish, what was going on, what were these concessions that were made. Let me also hasten to say, Chair, in my meeting with the chairperson, she mentioned whether I knew that Lucky Montana, Maisha Bopape, and then I think she mentioned Daniel Mtimkulu as the other ex-employees of PRASA, right, that were there. And she mentioned the three employees of PRASA that had made concessions. She did mention their names, and she said she was advised it was Mr. Kubue, Vincent Kubue, Mr. Baltic, Soren Baltic. These are people I know very well, Chair. And Mr. Vermeulen. Mr. Vermeulen. I couldn't remember Mr. Vermeulen, Chair, but the other two people that I interacted, regularly with.
These persons that she said had made or had given evidence before the 417 hearing, they were known to you?
Yes, I knew Mr. Montana. He was my group executive, group CEO at a particular point in time before he left. Yeah. So I knew him very well. I knew Mr. Maisha Bopape. He was responsible for SCM in the rail function. And I knew Daniel Mtimkulu as well. He was also an executive in the rail function. So I knew them well, Chair, and I knew the other two who were also executives. So what you have at PRASA, you've got group executives, and then those that occupy the general manager role. For instance, a Mr. Dingiswaya was the general manager, group legal services. So they'd be the second tier of executives within PRASA. So I knew all of them.
No, what I'm interested in, who is it that they claimed had made certain concessions at the 417 inquiry?
Well, in fact, it was all of them who had made concessions. I wasn't surprised, Chairperson, about Lucky Montana, Maisha Bopape, as well as Daniel Mtimkulu, if I recall. I wasn't surprised that they would make those concessions.
Yes.
I was concerned about the two who were current in their employ. Because remember, Chair, as I've explained, we work having received information from the business unit. So in my mind, I thought, how possible is it that these particular executives could have gone and made concessions about liability at the hearing when they told us a different story?
Well, we're getting to that. I just want to know, you were told by Judge Makhubele that concessions had been made at the 417 inquiries.
That's correct, Chair. I was told by her.
Yes. Did she mention the names of the people who made these concessions?
She did, Chair.
And how many that was then in the employ of PRASA did she mention?
The two, as I say, Mr. Vincent Kobue,
Yes,
Mr. Soren Baltic,
yes.
were still in the employ, and they're still in the employ.
And Mr. Vermeulen?
I can't remember Mr. Vermeulen, Chair, so I didn't know who he was.
So at this meeting, you left the meeting with information that somebody still in the employ of PRASA had made certain concessions at the 417 inquiry.
That's correct, Chair.
And how did that concessions affect the position of PRASA then?
You mean in terms of...
Well, what were you told?
Look, there was no detail,
Yes.
Chair. It was just concessions were made. I was hoping to get the report, Chair, and go through the report and understand exactly what those concessions were, because I didn't know. And naturally, you know, I was startled by the information. I went back.
Now let's just...
Okay, I didn't know, so...
You didn't know?
No, I didn't know the nature of the
next thing you
concessions.
say, you were startled by the information. What startled you about the information?
You know, the fact that we have this new information coming in, and it's coming from the chairperson who's very new in the organization. I would have expected, at least, to have been advised, right, of the concessions that had been made by employees of PRASA, so that if that was the case, right, we would then deal with effectively what was said by the employees to see the impact that those concessions had on the matters that we were requested to defend by them. And then we would then take the matters forward and say, guys, how do we then deal with this if these are the concessions that you made?
Do I understand you correctly then, that at this meeting, you were simply told that others and present employees of PRASA had made certain concessions. You didn't know what the concessions were, and you then called for a copy of the information, however that may be contained?
That's correct, Chair.
Yes. Now, what was Judge Makhubele's response to your request for the information as to how these concessions were made? Did she know? And could she give you the information?
She said she could not give me the report because of the collegiality, right, basis on which she had received the report. So I thought, okay, if this report exists, I mean, we can get it from our attorneys. It's okay. But at that meeting, she said she couldn't share the report with me.
Thank you.
Thank you, Chair.
Sorry, were the concessions to the effect that PRASA has got no defense?
Sorry, Chair,
According to you,
I didn't hear that.
the concessions that were made, were they concessions that to the effect that PRASA has got no defense to the claims of CI?
That's correct, Chair. That's what I understood from Judge Makhubele.
And therefore you must settle, PRASA must settle.
That's correct, Chair.
Just for clarity, for those who were internal, who were still in the employ of PRASA, did you try, when Judge Makhubele didn't give you the report because of the reasons of collegiality, how she got the information, did you try to ascertain or call a meeting just to verify the information?
Yes, I did.
Yeah.
I did, Chair. Because this was important, you know, for me to understand exactly what is happening. So we did make that call because I went back and I approached Mr. Tintswalo and I said to him, how come this information was not disclosed to me? And he didn't know about it as well. We then made contact with Mr. Tintswalo, with our external attorneys, Mr. Makhubele, and he didn't know about the report. We then called Mr. Kubue and Mr. Soren Baltic, trying to understand, and be on the same page with what the chairperson had communicated. So we did.
Thank you. Now, at this meeting that you had with Judge Makhubele, when it was indicated that she has the report, did she have the report? Did you see that she had something with her?
No, Chair, I didn't.
You went back and you say that you then called to the question from Ms. Silevu, from Ms. Maduba Silevu. She asked whether you tried to have a meeting to determine whether, in fact, to deal with these concessions. Did you have a meeting with Kobue and Baltic?
It was a call, Chairperson, because Mr. Baltic at least sits at head office. Mr. Kobue was in the division, but we called them both. We didn't, and it was an open speakerphone telephone call. So,
what was their response?
They did not make the concession. Mr. Kobue was alarmed, in fact. He denied it categorically and said he did not make any concessions. He doesn't know what is being spoken of. And Mr. Baltic the same. He said no, he did not make any concessions when we spoke to them. That's what they told us.
Now, from the meeting that you had, you indicated that with Judge Makhubele, you indicated that she called for reports.
Yes.
Right. Were these reports forthcoming? And from whom were the reports being requested from?
Yes. In fact, Judge Makhubele made it very official. So when I left, I understood that she wanted information in relation to these matters. She also made it formal, in a form of a memo that she drafted, requesting certain information. And then we then responded to that information from Judge Makhubele.
Okay. But with regards to Diale Mokhashwa, was there any report received immediately upon the request for a report with regards to the CIA matters?
Yes, Chair. If I recall, immediately after the meeting that I had with Judge Makhubele, it was specific that she wanted this report from our attorneys, and I requested for one, and one was provided by Diale Mokhashwa attorneys. And then there was subsequent the memo or email, I think it was a memo, that Judge Makhubele wrote, penned, and raised a couple of questions with Lindikaya Zide, who was the acting group CEO at the time.
Just before you go on them, before you go any further, Ms. Ngoye, I want to take you back to the reports that you say that Mr. Mokhashwa submitted. I want you to go to page 233 of volume 8. Page 233 of volume 8.
I'm the chair.
can proceed. Thank you, Chair. This document has got a letterhead for Diale Mukhashwa, and the document is addressed to Mr. Fani Dingiswayo and Ms. Shumi Mokotedi. Have you had sight, and it is dated 21 November 2017. Did you have sight of that document?
Yes, Chair. The document, after Mr. Dingiswayo received it, he shared it with me. So I remember reading it.
And who is this Mrs. Shumi Mokotedi?
Mrs. Shumi Mokotedi, Chair, is a senior manager in the legal function who was primarily responsible for these particular summonses and working with Diale Mukhashwa. As I've explained, we've got lawyers that would deal with various matters, and she was the contact person within the legal department dealing with these matters.
And, excuse me, and Ms. Ngoye, you've indicated that this report, you've had sight of it.
Yes.
Maybe because it is a long report, if you can just indicate to the Chair, what did this report deal with?
Chair, there's a summary of the various summonses that we had received from, from CIA, effectively. The judge at the time had requested that this information be provided. I mean, at the time, one read it and understood that that was there, and the lawyers obviously explained what each matter entailed and reported accordingly.
And from the reading of this document, did Mr. Mukhashwa indicate the defenses with regards to each of the summonses that had been submitted?
Chair, this is such a long time ago, I must be honest. I mean, I can't remember the specifics of this unless I'm given an opportunity to read it.
If you simply refer it to a paragraph in the report, if you want to ask a question regarding the report.
Okay. I'm going to refer you to page 235.
I'm the chairperson.
And in regards to paragraph of that, on page 235, paragraph 2.1 point, 2.1.9 first.
Yes.
That specific paragraph deals with the disputes between the parties be referred to arbitration, and that the present disputes had not been referred for arbitration, the one that is referred to in the paragraphs above. But he further goes on to say 2.1.10, the second defense raised in the plea. Can you see that?
Yes, I can, Chair.
Which is an indication, did it then sum up the defense with
Yes.
regards to that?
Yes, Chair.
And then 2.1.11, the third defense raised.
Yes, I can see that, Chair.
And then in paragraph 2.1.12, it notes the defenses also relied on clause 11.1 of the consultancy agreement to allege that. Do you see that?
I do, Chair.
And if you continue to go through this document, it outlines the defenses for each and every summons.
Yes, it follows, Chair.
And now, I just want to ask, at this stage, remember you've indicated that there was arbitration, that you were busy with the legal proceedings. Where were we with regards to those matters at that stage?
Well, as I indicated, Chair, as part and parcel of, the litigation, the parties agreed to take the matters to arbitration. And during that process, we then learned that CIA DB Engineering had applied for voluntary, liquidation. And
then what became of the arbitration proceedings?
The arbitration proceedings were, obviously suspended. And because there was no response, my understanding, it's as if the arbitration proceedings were effectively abandoned by the CIA, team because of this liquidation. The team was challenged, with getting information and responses from the CIA team in relation to, the information that they would have to provide next. And obviously this is the report that I had received.
After this report, which is dated the 21st of November, that came from Diale Mohashwa, you then, just before I stopped you, interjected you indicated that there was a memo that came from the chairperson. Is that correct?
That's correct, Chair.
Now, I want to refer you to 248, page 248, same volume, page 248.
I've got it, Chair.
That memorandum, it's written as urgent memo.
I can see that, Chair, yes.
And it is addressed to the acting group chief executive, Mr. Zide.
Yes, Chair.
From Chairperson Interim Board Advocate T.A.N. Makhubele, SC, dated 28 November 2017, subject CIA Consulting Engineers, Pty Ltd, inquiry in terms of section 417 and 418 of the Companies Act 61 of 1973. Have you had sight of this memo?
Yes, we did, Chair, because Mr. Zide, upon receipt of the memo, gave it to us as the legal department to assist in responding thereto.
And if you look at paragraph 1, it speaks to, I refer to various discussions between us about this matter, as well as our brief discussion with the Group Executive Legal Risk and Compliance, Ms. Martha Ngoye, on 14th November 2017.
That's correct, Chair.
And in paragraph 2, it says, I confirm receipt of a report from PRASA's attorneys, Diale Mohashwa, dated 21 November 2017. You note that?
I do, Chair.
And thereafter, it speaks to the CIA, it speaks to the CIA matters. That memo was speaking to the CIA matters.
That's correct, Chair.
It further, in paragraph 3, it then deals with the issue that Mr. Mohashwa or Mohashwa Diale attorneys were appointed to represent PRASA to deal with the liquidation matter.
I note that, Chair.
As acting group CEO, such instructions would have come from you.
That's correct, Chair.
I just want to pause for a moment on that paragraph. When the employees of PRASA went to the insolvency proceedings, you indicated that counsel had been instructed to represent them. Am I correct?
Well, to sit in the hearings, because our lawyers could not say anything at the hearings. Okay. So we asked them to support the employees that had gone there.
There was representation.
Yes, Diale Mohashwa did attend.
Okay. And then it obviously goes on to say, it also appears from the report that at some point the matters were referred for arbitration, but what is not clear is whether this happened before CIA Consulting Engineers went into the liquidation or not.
I know that, Chair.
Okay. Now, I want to pause there for a second as well. The indication is that she's not clear about this whole process. But when you go to the report of 21 November, which you had received from Diala Mokhashwa, it had set out exactly what had taken place in regards to the matters. Am I correct?
That's correct, Chair.
I further want to find out from you is that PRASA at the legal department, this legal department that you were managing or overseeing, does PRASA keep files for each of these matters?
We do, Chair. We do, where we don't keep the file. The matters would be stored on our PCs, on our computers, so to speak. But each matter, would have a file. That's how lawyers work. You would want to keep a record.
If Judge Makhubele at that time as chairperson, if she wanted access to the files, she would have been granted access to the files.
That's correct, Chair.
Okay. Did she ever request for access to the files?
Well, Judge Makhubele requested for files at a later stage, but it was various files. But at that time, she wanted reports. And one didn't see anything wrong with that, Chair, because she's new, she's trying to understand, the matters, and naturally the reports would assist instead of her getting the files and having to go through a ward of documentation. So the reports we felt were sufficient.
By this date when this internal memo is sent to you, which is the 28th of November 2017, had you received the liquidation report?
No, Chair, I've never seen the liquidation report. I mean, we had not received it. And as I explained, Chairperson, even Mr. Mokhashwa didn't have it. So we didn't have it.
And can I just ask, based on the response that you've just provided, until or between the time of the issue of this report of the insolvency report, from the time of the meeting of 14 November, right until the end of March 2018, were you ever presented with this report from the chairperson?
No, Chair, I wasn't.
Did Mr. Mokhashwa able to present you with this report?
No, Chair.
And from the persons that were mentioned, which would have been Kobuwe and Baltic, do you know whether they ever received copies of those reports? I
know they didn't. We asked, Chair. They didn't receive. It was important for us to get hold of this report, from our perspective, because as I explained, Chairperson, you don't want to just defend matters for the sake of it. You want to actually understand exactly what is happening. And it perturbed us, that there were these concessions that were alleged to have been made, and we just didn't have anything to see exactly what those concessions were. And I suppose, Chair, if one had the benefit of the report, one would see the nature of the concessions and then also determine whether, from the information that we had, those concessions would warrant us not proceeding with the litigation but adopting a different strategy. So one was in the dark. We didn't know what we were dealing with. But also the other thing is that the people who were said to have made those concessions said to us when we asked them that they had not made the concessions.
Well, there are two things that crop up from the suggestion, and let's leave it there, that concessions were made. Did you understand what was being told to you, that the concessions were made on record, because then you would be able to get a record of it?
Yes, Chair, I understood that.
Yes. And secondly, now, to get to what the concessions were, the people who made the or the people that were told who had made the concessions, namely Kubue and Baltic, as far as they were concerned, they denied that they made any concession.
That's correct, Chair. That's what they told us.
Yeah. So, as far as PRASA was concerned, PRASA never had the content of these confessions.
That's correct, Chair. We didn't have.
And you were looking for the content of these confessions.
Yes, Chair.
And could anybody provide you with the contents of these professions?
No, Chair. Not even our own external attorneys who were sitting there
Yes.
could provide us with this because they said they didn't have it and they were not aware.
Now, when that situation arose, that they couldn't provide you with these concessions, and I'm referring specifically to you,
Yes, Chair.
not the rest of PRASA, what did you think about these concessions?
Chair,
Yes.
you know, there was no specific detail, right? I got to hear that there were concessions that were made and that would have resulted in us not defending the matters and settling the matters. So, you know, as I said, without information, you know, I was left wondering what it is that we were dealing with. But I was assured, you know, with the team that was dealing with the matter, that PRASA has got defenses. And when I spoke to Judge Makhubele, I was very clear that no, Chair, I disagree with you because we do have defenses as far as these matters are concerned.
Well, that begs the question. Did you make it clear to Judge Makhubele that as far as the litigation against Siyaya was concerned, PRASA wanted to go ahead, irrespective of whether these concessions had or had not been made?
Yes, definitely, Chair.
And
I
when
did.
was that?
This was on the day of the meeting, on the 14th, when I had that meeting with her, and this issue was raised with me. I was very clear with Judge Makhubele to say, no, I don't agree with what you say. We have a defense as PRASA. We are going ahead with our defense because we do not believe that we are liable, as suggested.
And how did she respond to that?
Well, she said, based on the information that she has, we didn't, and we ought to have settled these matters. So there was that misunderstanding, Chair, or misalignment between myself and the chairperson, and she had the benefit of this report, which I didn't have a benefit of. But I just couldn't concede, Chair, based on a report that I had not seen, that yes, possibly we have a possibility of having to look at these issues and settling them. I needed to see the report, and that was important for me.
So if I understand the situation correctly, on the 14th of November, when you had this meeting with Judge Makhubele, then, that's 2017,
Yes, Chair.
you couldn't say yay or nay as to these concessions, and you were never in a position to see these concessions that were made, so you could never have been in a position to change your view, so to speak,
That's correct, Chair.
about whether PRASA should defend these matters or not.
That,
And PRASA had already, well, it was almost a year or two later, entered into and from the documents I see, have already filed their defenses to these actions. Is that correct?
that's correct, Chair.
Yes.
Yes.
Thank you.
Ms. Ngoye, just for clarity, when Judge Makhubele asked you for the reports or the files, were they meant for herself or for the board, the interim board, to discuss?
No, well, she asked them as the chairperson for them as the chairperson of the board, and my understanding was they were meant for her, not the board, but for her.
that was the process, any decision that would have been made by her out of having received those, what weight would it have?
So I'm not understanding the question.
The reports or the files are being furnished to her. She has this information. She looks at that, at the files. Then she gives you instructions, for instance. Or she gives a suggestion that you ought to have settled. Would that have been a direction to take without the board?
No, not the way we operated. I mean, Judge Makhubele would, at the time as a chairperson of the board, I wouldn't take it as an instruction from the board, for instance, if maybe I'm understanding the question that you are. And that's why when we approached this issue, it's important for the chairperson to be privy with what is happening in the organization and so on. So that particular, let's say for instance, she said, no, these issues would be settled. We, understanding the matters and having dealt with the matters clearly longer than she would have, because remember she was new in the organization, we wouldn't have just taken that instruction as just because I think this is every lawyer's conundrum, I suppose.
Judge Makhubele in paragraph 8, if you go to 4 lines down, 2, 3, 4, she says, however, despite these concessions, Mohasha Diale attorneys appear to still want to proceed with the arbitration proceedings. They, however, did not address the prospects of success at the arbitration proceedings in view of the evidence that has already been laid at the liquidation inquiry. Kindly confirm if these are your instructions to Mohasha Diale and the nature of evidence in brackets and witnesses that you intend to lead at the pending arbitration proceedings. My question, were you continuing with the arbitration process?
Yes, Chair.
And
sorry, let me not say anything. Perhaps continue, sorry.
Just a minute. On the arbitration, what did you intend to achieve? Was it settlement? What did you want to achieve?
But naturally, we had a defense. We had a defense. I think it's just a different forum, right, that would deal with these matters. So remember, we received summonses, which is a court process. So it was a different forum that would deal with this. But obviously, in relation to the merits that were there, it would continue to want to defend the position of PRASA.
I just want to ask you this, Ms. Ngoye. You are informed that the employees of PRASA have conceded at the insolvency proceedings, and yet you are still proceeding with the arbitration. I want to understand this. What are the findings from these insolvency proceedings? What effect do they have versus a finding at an arbitration proceeding?
Liquidation is a liquidation, Chairperson. Effectively, you've got another body, liquidators that are appointed, to deal with, the particular matter. And I guess that is why, from a PRASA perspective, we didn't have, for lack of a better word, jurisdiction to participate in those liquidations, because the liquidators were doing whatever it is that they had intended. So that was a process that we found ourselves having to be subjected to deal with. Because remember, Chair, also, DB, CIA DB was the one that went into liquidation. We had CIA Rail, which was not subject of a liquidation, and I think it's important to raise that as well. So at the end of the day, an arbitration would once finalized, would determine whether, as PRASA, it was proven that we owe a CIA or not, based on the evidence that would have been given, and would take it from there, depending on what was agreed as far as arbitration, whether you could take it up to the next level, And liquidation, you obviously had the liquidators who were interested in seeing, what was involved in the organization and who owed the organization's monies and so on. So I'm not sure if I'm answering your question, but one understands these things to work that way. And if we were somebody who owed CIA, right, the liquidators would decide whether they're coming for us or not.
In that correspondence, you are then requested that you need to provide a report as well. And it says, lastly, it appeared from our discussions in the presence of Martha Ngoyi that she was aware of at least the fact that there was a liquidation inquiry, kindly requested to write a report about the involvement of her unit, in particular with regards to provision of instructions to Mohashwa Diale attorneys on the issues that I've raised above. And the next paragraph, your report was due by the 30th of November 2017, which was to enable her to write a report to the Board of Control on 1 December 2017. Did you write the report?
Chairperson, the report was written from the department. It was written by Mr. Tintswalo, as the manager responsible. So he was writing the report, and he did write the report. And he did comply with the deadline of the chairperson as required, and we submitted it accordingly. What we did, chairperson, right, in light of the fact that this particular memo made reference to, things that Diale Mahashwa ought to have done and so on, we thought it was necessary that Diale Mahashwa, as our attorneys, attend to those specifics that were raised in that report so that we don't speak on their behalf. So we naturally, submitted the memo to Diale Mahashwa and said, please deal with the issues that pertain specifically to you. We didn't see anything wrong with that. And, so we provided our report, which was done by Mr. Tintswalo, and Diale Mahashwa also, taking cognizance of the deadline, also provided their report.
I want to refer you to page 259 of the volume 8.
got it, Chair.
Do you recognize that memo?
Yes, I do, Chair.
Is this the memo that you refer to as the legal unit having submitted to, in response to the memo dated 28 November 2017?
That's correct, Chair. That's the one.
Just the first paragraph of that memo. It's in the plural. You furnished us, and this usage of the words we.
Yes.
Indicative of not one person but many people having deposed to that. Am I correct?
No.
Why was it written in the plural?
Sorry, it's a question of style. I mean, I speak we. You know, I speak we, making reference to us as a department.
So it was a team.
Yeah, I mean, I think this is how we speak, and maybe it comes from training, but we, like I'm doing now,
Okay.
It's the legal department, it's we. Because this particular request was made to the legal department. So it is we. And yeah, it comes from Fani Dingiswayo, but he's representing the department. And that's why he says, we have shared, meaning all encompassing the department. We've shared the report with Mr. Dialamkhasha.
And Mr. Baltic and Mr. Kobu also submitted their reports.
Yes,
And
Chair.
if you look at page 255, it's a report to the Acting Group Chief Executive Officer, Mr. Zide, from Mr. Kobu, and he indicates, did you have sight of this report from him?
I think I did, Chair. Yeah, so long ago. I think I did have sight of this because I had engaged with, together with Mr. Dingiswayo, had engaged with Mr. Kobu on the particular matter.
And again, if you look at page 257, that is the report that was to 258. That is the report by Mr. Baltic.
Yes, it's got his name there.
And if you go on to page 266 of the bundle, that is from Diale Mokhashwa, and it is dated, it is emailed to yourself, Mr. Fani Dingiswayo, and Ms. Mokotedi, and it's dated 30th of November 2017.
Yes, Chair.
So all the people who had been requested for reports submitted reports.
Yes, Chair. It was coming from the instruction was the chairperson's instruction. You've got to comply with the time frames.
Now, once these reports had been submitted, we are now on the 30th of November. Okay. We are now on the 30th of November. The reports are submitted.
Yes, Chair.
What happens?
The 30th of November, I must try and recall also what we got, Chairperson, from Mr. Zide, following our submission of the reports, because we thought we had complied. He advised that the chairperson was not happy with the fact that we had shared her memo with external lawyers, and she was not happy with that, and she felt disrespected, and the issues. I can't remember if he sent it to us in an email or what, but we then responded, obviously, to that concern to clarify what it is that we had done and that there was no disrespect intended with the memo of the chairperson having been dealt with in the manner that we did. We didn't see anything wrong that we had done, and we thought it was important to then communicate to say, this is how we understood it. This is what we did to satisfy the requirements of the chairperson. So we didn't understand, the concern. And in fact, I remember Mr. Zito saying the chairperson is very angry. So you don't know.
Please, can I refer?
This is something new now, that the chairperson got angry, and that the chairperson is Judge Makhubele that we're talking about.
Oh, sorry, Chair. Yes. Yes.
When you had a conversation with her about concessions being made by witnesses from PRASA, you went in and you investigated whether such concessions were made, what they contain, and how it affected PRASA's position. That's my understanding.
That's correct, Chair.
Yes. To do that, you had to, speak to various people.
That's
One
correct,
of them
Chair.
was the attorney who was present at the 417 inquiry.
That's correct, Chair.
And at some stage, that's what we are now on, you say Judge Makhubele got angry.
Yes.
And when was that?
This was after we had submitted the reports. So she requested the reports to have been submitted by the 30th, because she needed to report accordingly to the board. And what we were advised that upon her receiving the reports, she became angry and did not appreciate the fact that we had what's the word I'm looking for? Shared her internal memo with external parties.
I just want to get clarity on that. So her anger, as you would put it, arose after the 30th of November.
Yes, Chair.
Yeah.
Yes.
Can you be more specific than that?
Chair, and as I say, this is quite some time ago.
If you can't be, it's not.
We understood that the chairperson was not happy. One of the things that she was not happy with, really, that we knew, and it confused us specifically, was the fact that this was an internal memo from her, right, as the chairperson of the board, and it was shared externally. So we needed to understand, maybe we're not on the same page with the chairperson. What is she alluding to that we shared the memo externally? Because we didn't. Finally, Tintswalo dealt with the concerns that were raised by the chairperson as the legal department.
I'm sorry? Yes.
No problem. As the legal department, we thought we had satisfied that particular requirement. But however, because there were specifics that related to Diala Mahashwa. Now, we didn't take Diala Mahashwa, chairperson, as an external.
Well, he was part of your department.
Yeah, he was part of the legal team. So we didn't think there was anything wrong that we had done, in relation to the concern that was raised by the chairperson.
And was the anger directed at you or was it directed at the organization?
Mr. Zide, as the acting group CEO at the time, effectively said, guys, can we explain this particular issue because the chairperson is very angry. And the chairperson was communicating with Mr. Zide. Yes, so the anger, I guess, because the chairperson felt that Mr. Zide is ultimately responsible, was directed at him, and he would naturally come to us to say, guys, I requested you guys to do this as the acting group CEO, and this is where we are. The chairperson is not happy with how, I guess, all of us had handled this particular matter, not excluding himself.
Just to clarify, so you didn't have direct communication with the Judge Makhubele at the time?
No, Chair.
So she had, in fact, communicated with Mr. Zwide. as you
Mr.
said.
Zide.
Yes.
That's correct, Chair.
So you learnt about her anger from Mr. Zwide.
That's right, Chair.
That's what I wanted to clear.
I hear.
Yes.
Okay, Chair.
Thank you. Thank you, Ms. Ngoye. I want to take you to volume 6, to page 788. Okay. Let us start on page 789. Because with emails, we know that they go, when you print them, it starts at the bottom and goes, so we will go backwards. Let us start on page 789.
789. I'm there, Chairperson.
Okay. The bottom email is dated the 28th of November 2017. It is from Tinswalo Makhubele and it is addressed to Mr. Zide, and the body is, please find attached herein is an urgent memo for your attention.
I
This
see
is
that,
on the
Chair.
28th of November 2017.
That's correct, Chair.
Right. Then, now you go back to 788 because we want to work the email in sequence. It looks like the memo dated 28 November was then amended, and hence the email on 28 November at 10:54 p.m. 10:54 p.m. Can you see that? That is now on page 788 at the bottom. Do you see that?
10:58. 10:54, yes, I see it, Chair.
10:54 p.m. You see that?
That's correct, Chair.
Right. The next email will be the one above, which is then from Mr. Lindikaya Zide to yourself. This is now on the 29th of November 2017.
That's
Do
correct.
You see that? Right.
That's it. Yes, I do.
And it says, dear colleagues, I had a bit of a challenge yesterday receiving my email, and I'm requesting that we action the amended memo. Mr. D, accepting that Sister Boss is not in, can you please action the matters contained in the attached amended memo? Can I also request that you alert Mr. Mohashwa and Mrs. Kubuwe, Baltic and Fermulen of the chairperson's request? Do you see that?
Yes, I do, Chair.
So, in other words, that memo was circulated by Mr. Zide with a request that Mr. Mohashwa be alerted.
Yes, Chair, but also naturally, you read the memo, and from there you would deduce that you would need to get information, even though Mr. Zide had said it in this email. And I guess I was not there at the time. I can't remember where I was at the time when the memo was sent. But, you apply your mind to what gets given to you and you deal with it accordingly. But it was obviously clearly also specific from Mr. Zide from this email.
Okay. I'm going to take you now to page 790. The email at the bottom.
Oh, yes, Chair. Can I say? Mr. D is Mr. Fani Dingiswayo. They call me Sister Boss. They call me various names, Boss Lady, Sister Boss. So the Sister Boss, they would be referenced to me.
Let's take you now to that email on page 790, which is from Tinswalo Makhubele, sent Thursday, November 30, 2017 at 5:21 p.m. And it's to Mr. Lindikaya Zide. And it reads, Dear Mr. Zide, please explain to me the reasons for sharing an internal memo with Mohashwa Diale attorneys. There was a specific instruction that was to be communicated to the attorneys. Why do you need legal assistance to respond to internal matters?
I know that, Chair. Yes.
when you indicate that there was anger, is that in reference to that email?
Oh, yes, Chair. You know how Mr. Zide was sat on the same floor, so you could walk to each other's floor. He didn't actually occupy the Group CEO's office that was sitting on the other side, although it's on the same floor. So we spoke, you know, and I guess this is then the reference to the email that he would have received to say, guys, you see, this is what I got that relates to that. And it became specific here that the external was Mr. Diale Mahashwa. As I said, Chair, we didn't regard Diale Mahashwa as our external, as an external party to the matter.
And Mr. Lindikaya Zide then responded as per the email above that email. Not responded, but wrote to you colleagues.
Yes, he said
bringing
that.
to your attention the email below from the chairperson.
Yes.
Okay.
Yes, Chair.
Is it correct? You then say that in regards thereto, Mr. Fani Dingiswayo then responded to this whole issue of these trailing emails with regards to the unhappiness of the chairperson.
Yes, Chair, because he had dealt with the memo and
if you go to page 792, that's what it's dated the 30th of November 2017, 10:48 p.m. from Fani Dingiswayo to Martha Ngoyi and Tiro Holele. That is the response that was there.
yes, Chair, that's the response from Mr. Dingiswayo following the email from Mr. Zide.
Now, this is all happening. This is now the 30th of November. It's in the evening, exchange of emails regarding the internal memo having been given to Mohashwa. What happens on the 1st of December?
Well, the 1st of December, we understood that there was a board meeting that was held, Chairperson.
Chairperson, I note that it is now 5:02. I don't know whether we can take the lunch adjournment and come back to start off with the events of...
Why is it when council wants to stop? Always referring to the top.
It's a habit.
Yes, we will take the run. Thank you.
Thank you, Chair.
can't.
Sorry, it's not my laptop, so I'm trying to figure out how to.
Thank you, Chair. This email, did it have a copy of the resolutions that was taken?
It had a document which purported to be a resolution from the board.
I want to refer you now to volume 6, page 799. Volume 6, page 799. Before. Oh, okay. Thank you. Ms. Ngoye, please can you confirm whether you identified that document? You're able to confirm whether or not that is the document that you received with the note from Ms. Kotu?
Yes, Chair, it is.
Okay. Now I want us just to briefly go through this document. If you go to page If you go to page 801 of the document, which is the last page of that document, do you realize that that document has not been signed?
That's correct, Chair.
However, you had been requested to deal with the resolutions.
Yes, Chair, we were.
Okay. And this document is headed as the certified extract of the special board meeting resolutions made at the meeting and it gives the address on Friday, 1 December 2017.
That's correct, Chair.
Right. Ms. Ngoye, there are certain resolutions which are on this document. The first one being the submission of litigation matters, and the request is that the executive legal risk and compliance must hand over all the litigation files relating to the contracts and or contractors emanating from the investigations to the office of the company secretary.
That's correct, Chair, I see that.
And then I want to go on to the fourth resolution, the status of the legal panel. And in regards to that resolution, management should provide a report to the board on the status of the legal panel and provide reasons why the legal department still uses a legal panel that appears to have expired. Under that resolution, it was the legal panel is suspended with immediate effect. Any legal services sought must be procured through SCM processes and in consultation with the chairperson of the board on all matters relating to the investigations only. You confirm that?
I confirm that, Chair.
Thank you. Now, am I correct that as a result of these resolutions, you responded thereto as per the request?
Yes, Chair. If I recall, one of the issues we raised because we realized that the resolution had not been signed. We requested a signed resolution from the board. And really because, things would happen and people would just say things are from the board. And you just didn't know whether it is true it is from the board or so. So we then requested a signed resolution to be provided to us. But we acknowledged what was contained in the draft resolution that was provided.
And
Sorry, just from whom did you request it and did you receive it?
No, we never received a signed resolution. We told Martha Kotu to say she should know better, she's dealing with the legal department. She must give us a signed resolution. And we requested same actually from the acting group CEO at the time to say you can't just give us a resolution like this that is coming from, the board, that purports to come from the board without it having signed. I mean, the company secretaries, they didn't need the authority of the board to be signed because it was an extract, from the resolutions of the board. So,
and when, sorry, Chair, I'm done. Just a follow-up question. You say that as well as the AG CEO, the acting
Group CEO at the
group
time.
CEO, who is this?
This is, it's Mr. Lindikaya Zidiche.
Now, did he provide you with a copy?
No, Chair, we never received a signed copy of the resolution.
Was he also part of that meeting? Did you ever find out whether he was part of the meeting of 1 December 2017?
He would have had to be because he's the acting group CEO of the board. So, of PRASA. So the group CEO would attend board meetings, Chair.
I'm going to refer you now to page 952. We are still on volume 6. 952 of volume 6. This is a memorandum addressed to the chairperson of the Board of Control of PRASA, Advocate C.A.N. Makhubele SC, and it is from Group Executive Legal Risk and Compliance, Martha Ngoye, and General Manager Group Legal Services, Fani Dingiswayo, dated the 5th of December 2017. The subject is draft. In your response in that minute of 5 December 2017, you dealt with the number of matters that your unit was dealing with. Am I correct?
That's correct, Chair.
And these matters appear on page 955. So let's just go to 954. You've set them out there. In paragraph 4.2.1.
Yes, Chair.
Which included the matters of Siangena Technologies, Shivambo Review Proceedings, KGP Media, and amendments against the Directorate for Priority Crime and Investigation, and the National Prosecuting Authority.
Yes, Chair, I see that. Chair, can I take you back before we go to the contents of the memo? I think it is imperative to look at paragraph 1, Chairperson.
On which page?
On our memorandum, it is page 952. Chairperson, you will note that the memo is dated the 5th of December 2017. We had been waiting for a signed resolution, and when we realized it was not forthcoming, we decided to deal with the memo, the draft resolution that we had received. And we were intentional in our approach to bring this to the attention of the chairperson of the board herself, because we felt she must know that this is what we had received, and not necessarily to, the company secretary who had given us the memo. I'd like to read paragraph 1, Chairperson, into the record if it's acceptable. We say we are in receipt of an unsigned draft board resolution for the meeting of the Board of Control of PRASA of 1 December 2017. With reference BOC resolution number 2, 1/1217. There are a number of concerns that this document raised with us, and we would like to point these out to the BOC. BOC would be the Board of Control, Chair. We hope that these concerns will be taken into account by the Board of Control before it confirms the draft resolutions to be resolutions of the Board of Control in its next meeting. This memorandum is drafted as advice to the Board of Control. We appreciate that the Board of Control is still getting to grips with PRASA and its operations, and that some of the matters contained herein may not be known by the Board of Control. We are happy to discuss the views contained herein with the members of the Board of Control. And then we continue. I think it was important for me to state that, Chair, because we were dealing with an unsigned document, and we didn't want to be seen to be adversarial as well in our approach. And so that's why, we were cognizant of not having that misinterpretation when one reads this particular memorandum coming from us.
Sorry, you did this in spite of the fact that the board is not correct?
Yes, we did, Chair. We respect.
You're aware of it?
Yes.
But you wanted them to deal with your response, yeah?
Well, the board was sitting, and it was said to have been a resolution of the board, Chair. I think issues of correction, were there, and I, with respect, believe that there were issues that were supposed to have been taken on by the board, really, at the end of the day. Because we had dealt with these issues before, Chair. We dealt with these issues with the board of Popo Malefe around correction, and this was an issue that needed to have been considered.
Thank you. I want to deal with this issue of the legal panel that you referred to. That is being referred to in the resolution, and that is referred to in your response in that memorandum dated the 5 December 2017. When we talk of the legal panel, what are we talking about?
Chairperson, as a state-owned enterprise, we are required to obviously go out to tender in relation to services we get from anybody. And the legal, function was not an exception there too. So therefore, there was a list of law firms that had obviously gone through the process, and we knew who they were, and they were the panel that would be briefed by PRASA in relation to various matters pertaining to legal issues within the organization. So it was a panel that was in place at the time of law firms.
And you, in your response on paragraph 9, on paragraph 6.2, page 961, you then dealt with the issue of the legal panel and its suspension. What were your concerns with regards to its suspension?
What page is it again, Chair?
961, but it's from paragraph 6.2.
Yes.
What are your concerns with regards to it being immediately suspended?
Chair, can I paraphrase what I'll
Yes.
go through them, because this was such a long time ago. One of the concerns that we had, having received this draft, was that we were advised that the legal panel is suspended with immediate effect. So we didn't know what that meant, really, in practical terms.
Just before you carry on, if we can just summarize quickly what it is that you're telling us.
Yes, Chair.
On the 1st of December, you received an unsigned resolution. Is that correct?
That's correct, Chair.
You then send it back, am I correct, asking for a signed resolution?
That's correct, Chair.
By the 5th of December, now we're coming to your memo, for want of a better word.
Yes, Chair.
This was still a concern of yours.
Yes, Chair.
And what you're pointing out here is, in particular, there seems to be a memo from the board suspending your unit. Is that correct?
It was a resolution from the board. Yes,
Yes.
yes, Chair. Yes.
And you were now writing back to the board on the 5th of December. And what is it that you were querying? Or
We sought clarity, Chair.
that's what you were doing?
Yes.
You were seeking clarity.
That's it, because in light of also the first paragraph, now that's why I thought, Chair, it's important that we talk to the first paragraph. We sought clarity because of having received this memo cold as it was, the resolution cold as it was. We are the department that is settled to dealing with legal matters, and there are ongoing legal matters on a daily basis. I suppose we get summonses, And when we read that the panel was suspended with immediate effect, what were we supposed to do? You get into this panic mode to say, what happens to the matters that we're dealing with now? What happens when a summons is urgent, comes in tomorrow? How do we deal with these issues? And the expectation, at least, that we thought we would have had at the time was that perhaps maybe it would have been necessary for the board to engage us as the legal panel and to try and understand from us why it is that we were dealing with this irregularity, because we considered it was an irregular legal panel at the time, but there were matters that were running for a very long time. So that was one of the main concerns that we had, to say, where does this place us as the legal function? We are supposed to also, having read that, we are then told that hand over certain files to the office of the company secretary. No qualms with that, Chair. That will do. It's easy. But we needed to understand the practicalities of what we were told out of this document in relation to us running the legal department and the realities that we were dealing with.
Yes, thank you.
I want you to turn to page 966 of that few pages later, the last sentence of that memo of 5 December 2017. 966. Can you read that out?
Is it the last one, 6.3.2? Or just the
That sentence that doesn't have any number next to it.
As stated above, we are happy to discuss these matters with the Board of Control or with any committees of the Board of Control. This memo is intended to be an engagement on the best interest of PRASA in delivering of the mandate of Group Legal Services.
Was there any engagement after this memo?
No, there was none, Chair.
What then did you do with respect to the matters that were outstanding and required counsel, and yet the panel had now been suspended? What then happened to the representations in those matters?
We continued, Chair, with the status quo, because if I recall, and I'd have to look back, and I think there was a proposal somewhere that the panel that must be used must be the SACA panel, South African Aviations, I think it was. So it was their panel that we were supposed to use, and what we understood was Regulation 16 was relied upon to get that panel. And we had advised the organization on the usage of Regulation 16 in respect of PRASA as a Schedule 3B, Chair, and that it was not applicable to PRASA as an organization. We dealt with that even before this particular board. So when we thought that, we thought this is actually telling us to replace an irregular panel with an irregularity. Now, and these were the things that we're trying to avoid. We are the lawyers. We understand the interpretation, and we would work with the board. And that's why when I started, I said, Chair, we were excited to have somebody with legal background to come in and work with us, because we struggled with this particular issue with the board of Opomolefe, who didn't have somebody with a legal appreciation of some of these issues. So, you find yourself now being stuck in this quagmire. And also, if I recall, this was in December. I just need to be reminded, Chairperson. Unite Behind was busy with challenging, the board and the issue of the chairperson. And we then got to see in one of I think it was a response, it was a replying affidavit. The evidence leader would have to assist me with where it is, if it is in the panel, in the documentation, where Mr. Lindikayazidi, right, who was the acting group CEO at the time, who would have sat in the board meeting, then deposes to an affidavit that says, this is not a resolution of the board. So,
if we can just get clarity on all that you said. You had an unsigned resolution,
yes,
from the board dated 1st of December,
yes, Chair,
2017.
yes, Chair.
This caused some confusion. First of all, it wasn't signed.
That's correct,
That was
Chair.
the first issue.
That's it.
The second issue raised is that you were now, well, for want of a better word, told not to deal with any pending matters. Is that correct?
Yes. We regard it, in fact, as a termination,
Well,
more than a suspension.
yes.
Yeah.
So that raised two issues. What were your future functions going to be? And two, what was going to happen to the matters that your unit was dealing with? Would that be correct?
That's correct, Chair.
And as this was still outstanding, you then wrote a memo to the board dated 5th of December.
That's
Is that
correct, Chair. That's correct.
Did you raise both issues?
Yes, we did. We did, Chair.
Just dealing with those two issues, did you ever get a response from the board?
No, Chair. There was no response.
And that caused you to continue as you were? so to
Yes,
speak.
Chair. We did.
Yes. Thank you.
You did based on the affidavit by...
I think the affidavit confirmed that we were on the right track. You know, because remember, we're left in limbo. We don't understand what this means. We're asking for clarity. We're not getting it. There are matters that are going. We got to defend the interests of PRASA, you know, and see how best we deal with this particular issue. And it was not out of disrespect. I need to state that. But again, you know, when you left with running, and when answers are going to be sought from you, I can't then rely on the fact that I exercised an unsigned resolution, you know, to leave PRASA's matters and to have PRASA get default judgments against it, you know, in relation to litigation that we were then going to get.
If I may, Chair, tell me, I'm trying to go ahead again, but today you have answered one of my questions previously by referring us to various other matters besides the CIA group matters. Is that correct?
That's correct, Chair.
And somewhere in the papers, we haven't arrived there yet, you make the allegation that Judge Makhubele paid special attention to the CIA group matters. Is that?
That's correct, Chair. I
You
did.
recall that?
Yes.
Why was it so, in your view?
Because
She left out all the matters you've referred us to today, yeah, and
Chair.
concentrated
Yeah.
on the CIA group matters.
Yes, Chair.
I'm just keen to know, before we adjourn today.
Yes, Chair. This is what I encountered, right, in relation to at least my engagement with Judge Makhubele at the time. She came in, there were all these matters. That's why I said in the first instance, she spoke to she wanted information on the worksman's reports, or the worksman's investigation. That I provide. This particular matter was of the most interest to Judge Makhubele, and it follows in her communications also in the organization that she was settled to deal with this matter. This was her matter, and anybody that wanted to deal with this matter had to engage with her first. And it's in that respect, Chair, because it's an unusual thing. It is in that respect that one is saying, clearly there was bigger focus on the CIA matters. I hasten to say, Chair, in relation to that specific time, we were settled with the Siangena matter. It was huge, Chair. Huge monies were at risk from a PRASA perspective. We sought, as the legal department, assistance from the board to say, help us. Here is this matter that we have now taken to court, and we're being asked for I think it was Rule 7 that was issued against the firm to say you don't have authority to act. And naturally, as the head, I knew that my authority in the circumstances was not going to be sufficient because I could draft an authority, a power of attorney, and say this is it. Mr. Dingiswayo wrote to the board to say help. You know, how do we deal with this matter? And there's no interest, even insofar as assisting the legal department, with that specific matter. When he wrote to the board, he addressed both matters. You know, both Yangena and this. And why I say this was the matter that Judge Makhubele was focusing on, because she had placed a lot of time on this particular matter. You know, and that is my assertion of what I'd seen at the time, and following, obviously, what transpired thereafter.
And the other board members, were they also interested in other cases, of the cases that you mentioned here?
Well, we gave this report to the board, Chair. We were never engaged, you know, in relation to the matters that we had raised with the board. It's information that was requested through that particular resolution, and we provided it. So I can't speak to the interest. I don't know, Chair, really.
By the way, I observed that you referring to Advocate Makhubele SC already in your evidence starting in October 2017 as a judge.
Yes.
The question is, when did you, I'm asking something slightly different now. When did you first become aware that Advocate Makhubele SC was about to become a judge, or is a judge, appointed judge of the High Court?
I think not long after she arrived, it was one of the things that, in fact, she indicated to me that she had been nominated or recommended to be a judge.
Well, I think the nub of the question is when, more or less,
this was in
your recollection.
This was around November of 2017.
Advocate Zuma, sorry, thank you.
Thank you, Judge Mashidi. Between this date now of your correspondence of 5 December 2017, can I rephrase that? When did you next deal with the CIA matter?
So in December, if I recall, Chair, the next time, let me explain this, Chairperson, to you so that I don't miss out certain things. In between December and January, February, we were aware as the legal department that Diale Mahashwa was, constantly in the building. We were all on the third floor with the chairperson's office, and we'd naturally bump into each other. Why are you here? The chairperson I'm having a meeting with the chairperson in relation to CIA. Okay, now we're not part of that. We don't know, but we take cognizance of that. So during that period, we realized that there was quite a number of meetings that were happening with the chairperson in relation to CIA. There was no engagement between the department and the chairperson of the board in relation to CIA after the memos that we had drafted. So naturally, one In fact, I did. I went to Mr. Zidi and I said to him, Mr. Zidi, I'm very concerned that I see Mr. Makhubele here and you are part of the meetings that are happening with the chairperson, with Mr. Makhubele, but the legal department is not there. You understand the policies of PRASA in relation to how legal matters are supposed to be dealt with. You know that a law firm, external, could not sit with any business of the organization without the presence of an internal legal advisor. Why is this practice going ahead? You know, and his response to me was, the chairperson prefers it that way. I left it. I'd raised my concern. He's the acting group CEO, right? I raised my concern. He knows that. This particular issue continued to bother us, chairperson, as the legal function, especially Mr. Ngusai and myself. We then decided we are going to phone Mr. Makhubele and ask him direct. He knows the rules of engagement with PRASA as an external legal firm, but he was not complying with them. We asked him on speakerphone. We said, Mr. Ngusai called and said, you know, we see you here. You're not talking to us. What is the story? What is happening? Why are you frequenting the organization and the office of the chairperson, but you're not engaging with us? You know, his response, chairperson, was, the chairperson has barred me from speaking to the legal department. Right? And I immediately said to Tinswalo, let's leave it there. So we left it because we don't want to get into discussions of why, do you know? We just left it at that, chairperson. And we accepted that as the legal department, we're not required in this particular discussions. But however, chairperson, we knew that this matter would come to us. That the CIA matter, yes.
We are talking about the CIA.
The CIA,
matter.
yes, I'm just making reference to CIA matter, Chair.
Yes.
Would come to the legal department one way or another. We'd get to know about it because the business, and this is a relationship that we had with the business was free to engage with us when they needed certain clarity. And, you know, it was understood that when it came to certain things, the sign-off of the legal department was necessary. So we left the chair and we thought, okay, we don't know what's going on. We left out of this thing. My first encounter with this particular, the CIA matters coming, Chair, was when the group CFO, Miss Yvonne Page, came to me. I can't remember the times exactly, Chair, but and I can be reminded. And she brought with me this document, which was a settlement agreement. And in this document, she said to me, I'm concerned that I am required to release the funds as a result of the settlement agreement, and I just needed to understand if you, as the legal department, knew about this thing and had supported it, because it came from the acting group CEO at the time, Mr. Lindikazidi, the way I understood it from Ms. Yvonne Page. So I then looked at the document. I read the document. I said to Ms. Yvonne Page, this document is a document that is concerning to me because I would not have advised the organization to sign a document that speaks to the fact that we do not accept liability, right? But still compels the organization to pay. That was contained in that settlement agreement, aligned to the fact that PRASA does not accept liability, but therefore must, this amount must be paid. But furthermore, Chairperson, what I then said to Ms. Yvonne Page, because the matters were dealt with properly, the divisions had their own mandates and delegated authorities to the group CEOs and the CEOs and the CFOs. I said to Ms. Page, I said, what concerns me is that these matters relating to CIA are not corporate matters, meaning group matters, right? They are matters whose budgets would be sitting in the divisions. So therefore, if anybody has to pay, it would not be the group finance. It would be the finance areas in relation to those separate divisions, because the budget was allocated to them. And this is the discussion that we had with the CFO.
You're not being asked about that specifically. At the stage where one page comes to you and asks you, as being someone in charge of PRASA's legal department,
That's right.
to sign a document. Is that correct?
Not to sign, Chair, seeking advice from me.
I see.
To-
Who had to sign? Who had to sign this particular document?
It was a document that was given to her that said, pay, because a settlement agreement had been reached. Right, so she brings this to me and she says, I have this. Are you aware as the legal department of this? There's a procedure, Chair, of how things, yeah. So anyway.
I just want to know, when she brought you this document and asked for advice concerning the contents, and what the document read is that there's been a settlement between PRASA and CIA. Is that
Yes,
correct?
Chair. That's right.
Now, at that, more or less, when was that?
This is where I'm saying I'm a bit fuzzy, Chair, as far as the time is concerned, but it would have been definitely January, February. I can't recall, Chair. It's quite a lot that has happened.
You can't recall?
No, I can't place it, but I know she came to me, Chair, specifically.
And in short, what was your, if anything, how did you respond to what she was asking you?
No, I said, you can't pay this. I said, you can't pay, don't pay this money, this settlement agreement. So I advised against paying.
Thank you.
Ms. Ngoye, I want to take you to a series of emails on page 288. Of volume 8. Page 288.
I'm there, Chair.
Okay. If you look at the bottom email, it is from Cromet Molepo. It is dated the 8th of February 2018 at 10:56 a.m. It is to Ms. Ramaphosa Nkakane, subject Siyaya PRASA. Do you see that?
I do, Chair.
And it says, Gogi, set up a meeting with Martha, LK, Peter, and Yvonne for this afternoon to process this matter. It has to be today. You see that?
I do see it, Chair.
Right. The email above is from Ms. Ngakane. It is dated the 8th of February, and it is at 12:10. Do you see that?
I do, Chair.
And that email is sent to Yvonne Page, Martha, Lindy, Zide, Malele, and the others. And it is, subject is Siaya, Dear Nana, please see email below. I will revert with the details.
I do see that, Chair.
I then go on to an email. This is now on page 287, so you've got to go back. The process is the other way. It says it's from Martha Ngoye, being yourself, dated the 8th of February at 12:22. So it's a continuation of the email from Ms. Ngakane, and you address it to Kromet Molepe, and then you CC other colleagues, which include Zide and Yvonne, and then you say, Dear Ntate Molepe, I have noted your instruction to Gogi for us to sit in a meeting today to deal with this matter. I find it difficult to be part of this transaction when the legal function was specifically excluded therefrom, and the lawyers were advised. We were informed by the chairperson not to engage with us. In this regard, I humbly request to be excluded from this matter because I do not support the manner in which this matter was removed from us and handled.
I'm aware of that, Chairperson. And may I say, Chairperson, at this time, that Molepo here I'm referring to is now the acting Group CEO. So Mr. Zide, remember I'd been saying that Mr. Zide, so Mr. Zide had reverted to his position of company secretary, and Mr. Molepo was now appointed the acting CEO at the time. That's why I'm addressing this letter to her.
Okay. Are you aware on whether or not the meeting did take place?
I'm not aware, Chair. I don't know.
Now this issue...
Sorry, I just want to put this. This is dated Thursday, the 8th February 2018.
Yes, Chair.
It deals with the CIR matters.
That's correct, Chair. That's correct.
And in 8th of February 2018, when you sent this email, this was your position. You had nothing to do with the settlement.
That's correct, Chair.
And that's what you were basically pointing out, and you were not going to get involved.
No, I wasn't going. I was very clear about that, Chair.
Yes.
Been excluded, and we were advised.
And now the last, on your evidence that you spoke about the CIR matter was a memo on the 5th of December. Is that correct?
On the
year previous, that's 2007.
So it was the November memo,
Yes.
Chair.
Yes.
So remember the 5th of December deals with the resolution, the draft resolution that we dealt with, yes. So it was in November, since we had submitted our report to the chairperson. Yes. That was the last time.
I just want to get the timeline correct so we can understand each other.
Yes, Chair.
When did you last have anything to do with the CIR matter?
The last time was in November, Chair. Mm-hmm. But then again, we picked it up, as I'd indicated.
Yes.
Yes, when it came around. Yes, Chair.
And January of 2018, was there anything there?
That's why I'm saying I can't recall exactly when.
That's fine.
Yes,
It's a long
Chair.
time
Ms. Yvonne Page came to me. But that was when I then, she came to me for that advice, and I gave the advice that I gave. But it was not specifically with dealing with the matter itself, as it had been discussed, but it was just advice to say, I've got this, can you help me out with it?
Yes, thank you.
Thank you, Chair.
So this meeting of the set up for the 8th of March, you did not attend.
The 8th of...
8th of February, you did not attend.
Yeah, I don't know if it took place, Chair. I don't know.
Then, in the bundle of documents, I want to take you to page 30 of your affidavit in volume 8. That's 30 of volume 8. 30. My mic. Sorry, my mic was off. It's volume 8, page 30.
I'm there, Chair.
There is an incident that appears to have happened on the 5th of March 2018. Can you tell us about that?
Yes, I do remember this distinctly. I was in my office and Mr. Tintswalo was in his office, and he comes into my office and he says to me, you'll not believe this, I've just received a call from somebody I know from outside of PRASA who wanted to confirm with me that it is true that PRASA had agreed to a settlement agreement and which was going to be made an order of court because his client, I think, was owed money by Makenza Mabunda, who is one of the directors of CIA. And he wanted to just get, confirmation that this indeed was the case. Because what I understood from, Mr. Tintswalo was that Mr. Mabunda, what his friend told him was that Mr. Mabunda had said, once this matter is settled, we'll be able to get paid. So Mr. Tintswalo picks up on this thing and becomes alarmed, right? To say how we don't even know that this matter is now in court, has reached the stage, right? He comes to me, he says, this is happening, we need to act very fast. Right, in relation to this particular settlement, which is going to be made an order of court. So what he did, he phoned Mr. Diala Mahashwa, who were our attorneys, and said to him, I've just been made aware. I'm with Mr. Tintswalo when all this is happening. I've just been made aware that this is the scenario, that papers had been issued to this, a settlement agreement which is going to be made an order of court. Do you have the papers served on you? He says, yes. In fact, in his response, Mr. Diale says, thank goodness you have phoned me, because I have been struggling to get instructions from PRASA in relation to this matter. So Mr. Tintswalo then said to Mr. Mahashwa, give us those documents that have been served on you. We will deal with those as a legal function. And that's what transpired, Chair.
Between this 8th of February, when you were requested for the meeting and you did not attend on the 8th of February 2018 and the 5th of March 2018, did you have any idea of what was happening?
No, we didn't, Chair. We didn't know.
Now, you say that Mahashwa was requested to hand over the documents that he had in regards to this whole issue. I want you to turn to page 294 of the volume. 294.
Which volume?
Volume 8, same volume, same document. Oh, God.
294, I'm there, Chair.
sorry.
If you look there, there is an email that is addressed to Mr. Zide on the 21st of February 2018, and its subject is Siyaya passenger rail. Do you see that?
I do see, Chair.
And it says, here we transmit herewith copies of the applicant's revised notice of motion applications in terms of which they seek to make the arbitrations award by Judge Brander orders of court. The revised applications were served at our offices on even date. Kindly be advised that these applications have been provisionally set down for hearing on the unopposed roll of 9 March 2018, and further that if we intend on opposing same, we should do so on before the 1st of March 2018. Kindly advise whether you want us to oppose the applications or simply let same proceed on the basis that they are unopposed. You see that?
I do see, Chair.
Now, did you approach Mr. Zide about once, or let me put it, when did you receive the papers that Mahasha was referring to, that is being referred to, that he had?
On the day that Mr. Dingiswayo made the call, this was the 5th of March.
Okay. And
Just before you carry on, this correspondence that's now referred to, that's at page 30. Sorry.
294.
294, volume 8. This
Yes, Chair.
Did you see this before?
No, Chair, we hadn't seen it.
So you don't really know what was going on by the 21st of February?
No, we don't know, Chair. We don't.
Yes. Thank you.
This is part of what Mr. Mohashwa gave to you, confirming that we had been waiting for a response in regards to the papers.
That's right, Chair.
Okay. And these documents, in regards to what he's talking about, is from page 294 to 297. The emails are page 294 to 297. The emails talking to these documents.
Yes, 294 to 297.
Okay.
Yes, Chair.
Now, he gives you these. Does he also place you in possession of the documents that were dealing with making this as the settlement a court order?
Yes, on the day that we found out that this was happening, we requested those documents because we wanted to deal with this particular matter, from a court perspective, and deal with the notice of motion that was served on PRASA.
On that very same day, on the 8th of March. What are you saying? Sorry, I was still on the 5th of March. I sorry, get the document. What then do you do once you receive these documents?
Upon receipt of the documents, Chair, we acted very quickly. We were very clear in our minds as the legal department that Diala Mahasha would have been conflicted in opposing these matters in court, right? Because he had been dealing he was part and parcel of what was happening in the organization as far as the CIA matters were concerned. And obviously because he was barred also, that was another thing. So we felt, okay, he's conflicted in his firm. He cannot deal with these matters. So therefore, we need an independent law firm to deal with this thing. We immediately briefed Bowman's Gilfillan.
When you say you immediately briefed a new firm, when would immediately?
It would be on the same day, Chair, because remember we're chasing time.
Yeah.
And we appreciate we're out of time. Mr. Mahashwa was indicating to us that, guys, I wasn't getting instructions from this. I didn't know what to do. I didn't know whether to oppose. I don't know what PRASA's position was in relation to these, because I guess he had his own discomfort with what had happened. But we were clear that we are going to oppose these applications. And on the day that we got the papers from him, we briefed Bowman's Gilfillan, and then we requested him so that it follows that he needs to send in a notice of withdrawal as attorneys of record in relation to this particular matter.
And that would have been in March.
This was in March, Chairperson.
Yes. Thank you.
He did, Chair.
Sorry. Did he file the yes, he did.
He did.
I'm sorry. My mic was off. And did Bowman's file their notice? Yes, notice of attorneys of record.
Yes, the whole thing was done properly, Chair. They filed and they opposed. They entered a notice of opposition.
Okay. Now, upon them, on the 8th of March, which is the day you say they filed, there is something that happens on that day. Chief, you can just bear with me. There's a letter I want to refer to. I want to refer you to page 289 of your volume, of the volume 8, page 289. Do you have it?
Yes, I do have it, Chair.
It is a letter addressed to you, and it is from Mr. Kromet Molepe, dated the 8th of March 2018. Do you see that?
Sorry, I'm 289. I was at 298, 289. Yes, I do.
And,
Chair?
Sorry, yes. And that, as I've indicated, that this letter is from Mr. Nzizwa Kromet Molepe, dated the 8th of March 2018, and it's addressed to you, and it says proposed meeting with the chairperson of board to discuss the CIA matter. That is the heading of the letter.
That's correct, Chair.
Did you receive this letter?
I did receive it, but Chair, can I take you back? Because I think we've missed a couple of days. And quite a lot happened in the 2 days before this letter that came from Mr. Molepo. So naturally, when we instructed Bowman's to act on our behalf and oppose, where they did, they received a Rule 7 notice to say you don't have authority, prove your authority. Now, this was my day-to-day functions, Chair, where, that was required because also in terms of the delegations of authority, I was preparing the powers of attorneys to say you are authorized to act on behalf of the organization. So we prepared those accordingly because they came back to us and said we are challenged. We prepared those naturally. We forwarded it to Bowman's to serve. And they did, right? So we were fine. We're going to court, right, on the 9th. This is the day that the matter was set down for. What then happens, Chair? I think it was on the 6th or 7th, 2 days before. So we're quite comfortable that this matter is going to be opposed, and we're proceeding with it. Mr. Cromet Malepo calls me into a meeting. It is myself, it is Diala Mahasha, it is it's Mr. Mahasha, you know, I refer to, it's Mr. Lindikaya Zide, it's himself, it's Mr. Tintswalo. We then explain to Mr. Cromet Malepo what the plan was. We told him that we understand that this is what has been brought to our attention, that the arbitrations that were supposed to have been dealt with by the organization have now been settled, right? And the settlement was going to be made an award. We don't agree with it. We have then decided to brief Bowman's, right? Mr. Mahasha is sitting in the meeting, and he conceded that he was conflicted because we said to Mr. Cromet Malepo, we can't proceed with Diale Mahasha, they're conflicted. So this is where we are. We're going to proceed and oppose. He agrees. No issue about that. Martha, I support your team. Go ahead and oppose this application. I act on advice of the legal department. You know, I feel got a vivid memory of what transpired in that meeting. So we left, thinking that this is what we're going to do. The group CEO is away. He's in support of what we are going to do, and we proceed with the transaction with the lawyers that we had briefed. Now, I need to say, Chair, the letter that the evidence leader is referring to is dated the 8th of December. 8th of March. On the 8th of March, Chairperson, I'm in a group exco meeting, right, with the group CEO and the rest of exco. Mr. Tintswalo is in his office. Unbeknown to me, and I had requested Mr. Cromet Malepo to allow me to engage with the chairperson around this thing. It was not happening. In fact, on the 8th of March, the chairperson was at PRASA, sitting in the next room to where the EXCO meeting was being held. So yeah, I requested a chance. I can't just barge into the office of the chairperson. I respect authority, Chair. So through the group CEO, I requested this. It was not happening. So I left it. We went into group EXCO, right? Mr. Tintswalo is preparing to go to court the following day. I needed to leave early to go home, and I'd advised the group CEO that my child has got a parents' meeting, I need to go. So as I leave EXCO, I approach Mr. Cromet Malepo, who is sitting with close to Mr. Zide, because I just couldn't walk out. And I'm saying, Chair, as I indicated, may I please be excused? On saying that, Chairperson, it's like the both of them were in sync. They say to me, you cannot oppose this particular application that is being heard tomorrow. And I said, what? I said, what is the basis of that? No, the chairperson is very unhappy. We can't oppose this matter. So the instructions are not to oppose. I flipped, Chairperson, at EXCO. And I was very clear with the group CEO. And I said to him, Mr. Malepo, I don't take unlawful instructions. And as far as I'm concerned, this is an unlawful instruction coming from you. We sat with you. We agreed with you that this is what you're going to do. We have prepared for this matter to go ahead. On the eve, you want to tell me that now we are not allowed to do this. what is the basis of us not being allowed to oppose these matters? Because as far as we are concerned, PRASA does not owe CI. In EXCO, chairperson, sits the executive of the two divisions whose matters these are. I stand up and I say, Mr. Monsami, who is the executive responsible for technical, PRASA technical, I say to him, are you aware of the settlement? Did you guys agree to this? He says to me, no, I'm not aware of it. And I don't agree that we owe CI. I say to Mr. Pete Sebola, sorry, Chair, I'm pointing because I remember where they were sitting. Mr. Sebola, are you aware of these settlements? In the presence of EXCO with Mr. Molepo and Mr. Zida sitting there, he says to me, no, I don't know about these settlements. And I wouldn't agree that we settle. And I said to Mr. Molepo, I said, on the basis that even the group executives of these respective divisions have not given the go-ahead that these matters be settled, we are going to proceed tomorrow and oppose this matter. Because I don't know what is going on. But as far as we are concerned, we are going to protect the interests of PRASA in this particular matter. I took my bags, I left, Chair, out of EXCO. It was drama, and I must confess there was drama. And I guess it's the best drama that can be performed by a woman at that time. I was just determined. I left. I went to Mr. Tintswalo's office. As I walk into Mr. Tintswalo's office, he says to me, you will not believe what has happened. Because I was going in there to tell him what I had been instructed by the group CEO with the company secretary. He says, no, relax. And he'll speak to this, Chair. He says, you won't believe what has happened. I've just received basically correspondence that indicates that the chairperson has been communicating with the other side's lawyers and saying, we do not have authority to have briefed Bowmans because Bowmans is not on the panel. So leave it. We are going, this is very strange, and this is now coming from Motapo attorneys. Right? Remember, CIRDB is in liquidation, chairperson. So naturally, Motapo should not be involved in this thing. At least that's how I understand it. Right? But they're in the lead as far as this is concerned. So Mr. Tintswalo says to me, this is bizarre. It cannot happen. But we are going to proceed because you've done the powers of attorney. I'll proceed to court tomorrow. I become very perturbed with this behavior, chairperson. I pick up the phone. I phone Director Kolile George. Director Kolile George had been sitting on the board of PRASA. He was a representative from Salga, sitting on the board of PRASA at the time. So I say to him, I say, Director George, what is going on? Are you aware that this is happening? Now we are being told we cannot oppose this CIR matter, the settlement. We do not agree. So I basically tell him what is happening. Director George says to me, fight this thing. That's what he says to me on the phone. He says, fight this thing, escalate this thing. Right? So I do, in fact, he says to me, you can write to the PCO2, write to the minister, escalate it. Now, he's a board member, right? I go back to Mr. Tintswalo and I say, right, you write to the minister, I will write to the PCOT, because we've gone to the board to say, help us out, and they're not saying anything as far as this matter is concerned. And that's what we do, Chair. We write these letters. On the 8th. I go home. The following day, it starts as the 9th, that's the hearing. I'm not aware of this memo from Mr. Mlambo, right? I come in and I do my work, and I'm concerned about Mr. Tingiswa as to what is going to happen. I pick up this memo later in the day. I look at it and I'm thinking, the horse is bolted anyway. Based on what was said in the memo, I knew I was in trouble, because it's happened. Mr. Tingiswa is in court. We've proceeded. But there was justification for my behavior on the day. So I didn't respond to Mr. Molepo's email. I did not heed his call, as he had written on the day.
Stop you there so that you explain what this memo says.
Yes, Chair.
What was said in the memo, and I would like to refer you. It's addressed to you, as I said. It's on page 289 of the bundle, and it in the memo, in the body of the memo, in the middle, there are three issues that are there, but the first two are important. And it says, I met with the chairperson together with the company secretary as discussed. The purpose of the meeting with the chairperson of the board was to discuss the CIR matter. The chairperson was willing to have a meeting with the AGCEO, company secretary, and legal, provided that she is advised whether her decision to settle the CIR matter is being reviewed or challenged. In this request, the chairperson directed that should it be that a decision has been taken to oppose the application of making the settlement agreement a court award, then the chairperson should have been engaged to understand the rationale of the opposition.
I note that, Chair.
Had you ever been provided with an opportunity to engage the chairperson with regards to the settlement agreement?
No, Chair, and as I said to you before, I had requested Mr. Cromet Mlambo to say, I would like to speak to the chairperson about this, but he wouldn't allow me to. This was on the 8th of March. So I wasn't allowed to do that. And then I received this. As I say, I only saw it later on in the day, clearly at least after Fanny Dingiswa had gone to court.
I want to refer you to...
Just to clarify, the chairperson being?
The chairperson is Judge Makhubele. Yes, Judge Makhubele. That's right, Chair.
Yes.
Sorry, and did you meet her on that day?
No, I'd not met with the chairperson, Chair. So it proceeded to court without us having had an opportunity to meet. But also, when you read the letter, Chair, I read it and I thought, if there's a condition placed on this thing anyway, but we were going to proceed opposing the matter, it was happening and we need to move fast. So,
just to go ahead quite quickly, what then happened at court as far as from the correspondence?
When Mr. Tingiswa will speak to this, he was there, but he reported back to me, Chair.
He went to court.
He went to court personally.
Yes. And
yes.
he will tell us what.
Yes, he'll tell you what happened, but he reported back to me when he came. He said, listen, we lost.
To testify.
Yeah, it's a default judgment, yeah.
But as far as you know, when the matter got to court on the 9th of March, somehow or the other, whatever the matter proceeded, and PRASA lost, so to speak.
Yes,
Yes.
we were not there, Chair.
Yes.
Yeah.
Thank you.
Well, at least that's what the judge said, didn't recognize that PRASA was in attendance.
Just for clarity, all along, the basis not to oppose were that Bowman's is not properly authorized.
That too. This matter was dealt with, the way it was dealt with internally, and remember I said we were not part of it, but also coupled with the fact that we understood that Bowman's could not represent us because, you know, one, I was not authorized to have briefed Bowman's, right? And they couldn't act for us because they were not on the panel of SACA. So it was a combination of factors.
Thank you. Ms. Ngoye, I have to take you through this here because it becomes very important with regards to this whole issue. The letter that we've just been dealing with. What page is it? Okay. I want to take you through again to that letter, and it further continues to say that they are requesting that you had a meeting to deal with the issues raised by the chairperson to ensure that PRASA's reputation is not brought into disrepute. And it is common cause that PRASA will find it difficult to convince the court in this matter without revoking the admissions of liability given by the PRASA employees during the inquiry process at which PRASA was legally represented. In this regard, I'm in no way giving an unlawful instruction, but I'm directing you to withdraw the opposition so that we can deal with the issues raised above, including the genesis of the concessions made at the liquidation. And understanding you continue to court.
Yes, we did, but Chair, also this letter doesn't make sense, really, and with the greatest of respects. You know, we didn't have legal representation as one understood it, the way the CEO drafted it, because I think because he was also grappling with the issues at the time, because he was new, you know. And when you want to say you are acting in the best interest of PRASA, what is the best interest of PRASA? To pay a debt that you have conceded you don't have any liability for? It just didn't make sense. I read this afterwards and I thought, well, it's water under the bridge because we've proceeded.
And the correspondence you say that was sent to Bowman's dated the 8th of March 2018, that is the one that is on page 298 of the same volume, 298, 299 to 300.
(298), yes. Yes, Chair. So this was brought to our attention by Bowman's having received this from Motapo attorneys, who were CIA's attorneys.
Okay. And in that correspondence on page 299, paragraph number 2, it says your purported notices of invitation to oppose the 4 applications are irregular and you do not have any mandate from the board of the Passenger Rail Agency of South Africa to represent it in these applications and to oppose the applications on behalf of PRASA. Advocate Annah Makhubele SC is the acting chairperson of PRASA's board. After we received your purported notices of intention to oppose the 4 applications, we requested Advocate Annah Makhubele SC to indicate whether or not the board of PRASA has decided to oppose the 4 applications. Advocate Annah Makhubele SC response was as follows. Then in italics, there's a response that is contained therein.
That's correct, Chair.
Which reads as follows. Those attorneys have no authority. PRASA's legal panel has been suspended since 1 December 2017. We are using SACA panel. I know that you couldn't have been appointed through that panel. Only those who have instructions already only those who had instructions already continue. I've just asked Mr. Zide. He says decision was taken by Martha Ngoye and the current AGCEO.
I know that, Chair.
Right. So this is something that was then brought to your knowledge.
Yes, Chair.
Okay.
As I said, when I went to Fanny Dingiswa's office, because I was not aware of this, I was in EXCO, and he had received this from our attorneys.
I want to take you to page 272 of the same bundle. a letter that was addressed to Diale Mohasha, attorneys, and it is dated the 15th of December 2017. Do you note that? Do you note that correspondence?
It's dated 15 December 2017. Yes, I do. I've got it, Chair.
When Bowman was opposing, or when filed their notice to oppose, did you have sight of this correspondence?
No, Chair.
You had not had sight of this
No,
correspondence?
Chair. We didn't have. We didn't have it. No,
Okay.
we didn't know this.
Sorry? Okay. You get to, Fanny comes back from court. Sorry, before I get there. So does Bowman appear on your behalf now on the 9th of March 2018?
Yes, Chair. Bowman does appear.
And Fanny is in court and he comes back and he makes a report to you.
Yes, Chair.
What does he state to you?
He says we got default judgment. The judge did not recognize the presence of PRASA because, based on what Advocate Boertes had indicated in his submissions and with the proof of, the communication they had with the chairperson of the board, it was decided, the judge, I think it was Holland Mutter at the time, decided that PRASA, it's like, we don't see you in court, and therefore he gave default judgment.
And how much was involved in this matter at that stage for these, how much was involved, these claims? How much did they amount to?
It was circa 56 million rands, Chair. 56 million rands, and the what we understood was that there was interest that was added on the amounts. Chair, may I please request another bottle of water, if it's. Thank you, Chair. I'm just feeling trying to.
subject or the amount involved in this whole matter.
That's correct, Chair.
Okay. Just one specific thing that I would like to ask before I go on to what then happened thereafter. This power of attorney, I want you to refer to volume 9, that is before you, page 675.
I've got volume 9, Chair.
Is this the, sorry, do you have it?
What page?
Page
Sorry.
675, volume 9. Is it volume 9? Yeah, volume 9. I can't see this.
I'm there, Chair, yes.
Thank you. This special power, it says a special power of attorney, and you, I, the undersigned Martha Anika Ngoye, the Group Executive Legal Risk and Compliance of the respondent herein do nominate, constitute, and appoint Bowman Goldfillen Inc. to be the respondent's true and lawful attorney. This is the document that had been given to Bowman's.
That's right. That's what I signed, Chair.
And this is the document that was being said it is not, it's non-existent. You can't authorize them.
Yes.
That was being contested.
Yes.
Okay. Tell me, Ms. Ngoye, this document is marked, is noted as being issued on the 8th of March 2018. I just
Yes.
want to get an understanding. Is this the only power of attorney that you had given, or are the other power of attorneys that you had been given given to other legal firms between, let's say, 1 January 2018 and the 8th of March 2018?
Chair, I used to have to give these ever so often whenever the authority of our lawyers was challenged in terms of Rule 7. So, in other cases it was fine. We would proceed without. So, I used to do these things on a regular basis.
But from your memory, this was the only one that got challenged and said it was non-existent at this time.
That I didn't have authority, yes. Yes. Otherwise it was okay. Yeah.
There was no
I understand, Chair.
Okay.
Well, let me just put it clearly. You usually sign powers of attorney.
That's correct, Chair.
And you had signed this one on the 8th of March.
That's correct, Chair.
And as far as you know, this is the only power of attorney that was ever challenged.
Yes, Chair.
As far as you can
As far as I know, yes, Chair. It was the only one that was
this was
challenged.
the only power of attorney, as far as you can recall, that on the 9th wasn't good enough for Bowman's to appear.
That's correct, Chair.
And that's the situation we are confronted with.
That's correct, Chair.
Just one more question. Did Mr. Dingiswayo have this with him, or Bowman's had this with him on somebody from Bowman's or the counsel who appeared for Bowman's? Did they have this in their possession?
At court?
At court.
Yes, they did.
I see.
Yes, Chair.
Ms. Ngoye, the application default is given on the 9th of March. What then happens?
Chair, obviously we were distraught. It was just one of those things that we really didn't want to have to deal with, because we believed that we could stop this from really going further. Remember, Chair, I had indicated that on the night of the 8th, we had escalated to the Minister, to the Portfolio Committee of Transport, because in our view, as the legal department, we felt we've got no help internally. So what we wanted to do was to then have authority to apply for rescission of the matter, and that was our biggest focus after we had received the default judgment. And so we started working towards that, and obviously after having engaged with the Minister, we then got an answer from the Minister's office to say he wants a meeting with the legal department, together with the chairperson of the board and the group CEO. So we were ready to go and see the Minister after this.
Before we get there,
Before you carry on, well, what was the outcome of all of this?
Of what, Chair?
Now, from the 9th of March onwards, what happened? Just shortly, if you can. You went to see the Minister.
Yes.
And what was the Minister's instructions?
We needed to do a report.
Sorry?
We needed to do reports, in fact.
Did your report?
Yes, the legal department did the report.
Yes.
I don't know about the chairperson.
And then what happened afterwards?
Later on in the month, the Minister gave the go-ahead to say we can rescind. He said, go get PRASA's monies back.
And did you go and rescind?
Yes, we did. Chair.
And then what happened?
And we got the rescission.
And what has happened since then?
We got the money back. The sheriff didn't pay the money, so we got the money back. And yes.
And
after that, Chair, I received a memo from Mr. Kramet Molepo. I needed to explain myself.
Yes, no, just...
In terms of the conduct.
Somebody can else ask you about that.
Yes.
I want to know. How did this thing finally end?
Well, we got the money back, Chair, and the chairperson in the interim had resigned. So we just continued.
Yes, no, but Chair. What about CIA? What happened to them? They got the judgment.
Yes.
Did they pursue it?
No, they didn't.
Up to today, as far as you
Well, Chair, I know that they keep going to the Minister. They keep going to the Department of Transport.
Yes.
Because I encountered this in the next board.
I see.
Yes.
But as far as you know, did it ever go back to court? I mean...
No, we've never proceeded this matter to court, Chair. So even when we did the rescission application, responses coming from CI's attorneys was not there. So effectively, we had to remind them to say your answer is supposed to come in at a particular date, and they never happened.
So the judgment was rescinded, and as far as you know, it had never gone back to court?
No, Chair, it had never gone back to court.
Not yet?
Yes, yes, Chair.
This was in 2018. I know it takes long sometimes.
Yes, Chair. It's never gone back to court.
I see.
It's just gone to the Department of Transport.
Mm-hmm. And they're sitting with it at the moment?
Well, they're sitting with the instructions were this matter that has been brought to our attention, and the supplier is complaining that PRASA owes them money. And we would always say, we don't owe, there's a court process that's still pending.
Thank you.
Sorry, what happened to the money that was attached in
the money was reverted back to...
Sorry?
The money was reverted back to PRASA from the sheriff.
To PRASA?
Chair, yes.
Thank you.
Thank you, Chair. So after the 9th of March 2018, when you were being questioned by the chairperson, there was a response, an indication that there'd been the money had been with the sheriff. When was that?
Well, the sheriff took, the way I understand it, it happened so quickly even after the awards were made, the settlements were made in order of court. The attachment and the execution happened so quickly, that we found ourselves, in fact, on the 12th of March, Mr. Dingiswayo writes to CI as attorneys to say there is an intention to rescind. right? And therefore we are going to proceed with it. But at that time, the money was already attached and removed out of one of our bank accounts.
And then did you then bring in any application after that to deal with this money that was in the bank account of the sheriff?
I mean, I guess it follows the process. This is the interdict that we sought because we were rushing time, Chair. 9 March, 10 April, the sheriff was going to take the money. He was not interested. He needed a court order. We had to work and get that court order. And we got it on the 8th. We stopped him. We got the money back. And then we had to proceed with the rescission because we agreed that we'll expedite that process. It was Part A and Part B of the matter.
Who was assisting you now on that at that time? Which legal firm was assisting you during this interdict proceedings?
We continue to use Bowman's.
Was there any problem with the appointment of Bowman's at this stage? No,
They were not
problem.
challenged. Yeah.
Okay. I just want to take you to thereafter, when you got the money back, there was still this default judgment. You say that there was a rescission application that was brought.
Yes, when we did the initial one, we just did it Part A, Part B. And we agreed with Judge Ranchard, in fact, that we'd ask for an expedited hearing of the Part B because the matter was so important and it needed to have been dealt with.
And I think from the questioning by the chairperson as well as Judge Moshide, you indicate that you were successful in regards to the rescission application.
That's correct, Chair.
And that is the affidavit that we've been dealing with today. In Volume 8, that is the affidavit with all these attachments that was used in the rescission application.
That's correct, Chair.
Okay. Now, is it correct that since that time, they've been the CIA issue has never proceeded any further?
It has never proceeded. It has never gone. It's not gone away, Chair. It's still there.
Your understanding, after that rescission application, that was before Judge?
The rescission was before Judge Tochten. So let me just, yes, Judge Ranchard dealt with the interdict, and then Tochten dealt with the rescission.
Now, after that rescission had been, you were successful, has CIA brought any further applications to get this money that they were claiming?
Not in court, no.
Maybe, Chair, it is a good idea to stand down until tomorrow. I think one is a little bit tired.
Chair, through you, before we adjourn, there have been reference to several documents, including litigation, by Ms. Ngoye. We have looked at the record up to this point. We don't find those documents in the bundle. We wonder whether through you we can appeal to Ms. Ngoye to get those documents to us tomorrow.
Well, Advocate Maleka, if you let me have a list of the documents that you want, I would certainly try and facilitate that you could have the documents by tomorrow.
Thank you. Can I just mention those that I remember offhand?
Yes.
You asked Ms. Ngoye whether she made affidavits to Judge Zondo's commission. I think that's how you put them.
I think Judge Mashidia.
No, I recall it's you, Chair.
Yeah. Yes.
We read the transcript of evidence, and Mr. Soni did refer to at least 2, maybe 3 affidavits she has made to the Zondo Commission. Can we appeal to her to the best of her efforts to make them available to us?
So it's the affidavits that were presented to the Zondo Commission by the witness.
Indeed.
That's one, yes.
And secondly, there has been a dramatic eruption around the valid constitution of the board and the decisions that it may have taken. Our understanding is that there was an application lodged by the complainant in the Western Cape High Court, and that PRASA opposed that application. Through you, may we appeal to Ms. Ngoyo, to the extent possible, to get us
The application that was brought in the
Western Cape High Court.
I don't know if Ms. Ngoyo would be able to produce that, but we will.
We understand from the inquiries we've made that Mr. Zide deposed to the opposing affidavit. Of course, she was still head of legal.
Yes, so she may have had it.
Indeed. If she could, but if she can't, we understand. But we would like to have a look at those affidavits because they're quite key.
Yes, certainly.
Yes.
Anything else?
The last thing is whether she could tell us that the only affidavit which is before us she has made in any proceedings that are relevant to this issue is the rescission application, founding affidavit.
Whether she made an application in the...
Whether there is any other affidavit.
Other than?
Yes.
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 So you're looking for 3 sets of documents, as
Indeed.
I understand.
Indeed.
Yes. If you just give me a minute. Advocate Zungu, you've heard... Oh. That's fine. Advocate Zungu, you've heard what is being requested. And I think, ma'am, you've also heard what was being requested.
I have taken a clarity,
Yes.
please, just for my benefit. Mr. Baleka is asking for the affidavits that I made to the
Yes.
Zondo. I made more than 3 affidavits. Does he want all of them?
Well, can you get all the affidavits that you may have made to the Zondo Commission?
I'll get them through my lawyers, current
Yes.
lawyers, Chair. I'll attempt to
A
get them.
set of affidavits, if you had made any,
Yes.
or all the affidavits that's been made in the application on behalf of PRASA in the Western Cape High Court, I understand.
The first are the Zondo Commission affidavits.
Yes.
The second is the affidavit, the papers in the Western Cape litigation.
Yes. And the third one is
Any other affidavits
any other affidavits.
of relevance to your mandate.
Yes. Do you understand?
I do understand. I'll confer with the
Evidence
the
leader.
evidence
has to-
leader, Chair.
If necessary, we can take it offline with our colleagues and Ms. Ngoya.
Yes, certainly you may. But I think it's understood what is being required.
That's
of you.
correct, Chair. Understood.
Yes. Thank you. We will then, is there anything else, any other business? We will then stand down until 10 o'clock tomorrow and we'll take it from there. Thank you.
Thank you, Chair.
That's okay. You want to leave in one point.